May I please, my lord? My lord, I beg to mention item number 4, ma'am. Yes, madam. My lord, I have taken consent from the other side, madam.
In this case, I am appearing on behalf of the FCI, my lord. My prayer is that a fixed date may be given since I come from principal seat, my
You
lord.
for the respondent.
I'm for the respondent. So 10th of November, you will be suitable after vacation, my lord.
After vacation,
Yes, 10th of November, ma'am.
10,
10th of
November.
November. All right.
My name may be recorded, my lord, VK Singh for FCI, my lord.
Yes.
Obliged.
All right.
My lord, I beg to mention item number 3, my lord.
3,
Yes, I have obtained consent from the other side, PP
2 and 3.
3.
That is both are analogous, 2 and 3. MSc matter? Yes. 16. Which one? Okay. Then 4 IS, you know,
All right, may be taken up after 4 weeks.
revision, no? Revision
Yes.
matter, 3.
Obliged.
My lord, this is mentioned for this bail application for this Papu Hill PS case 45 and Nalagan PS case 132. This may be here together with item number 18. That's bill hearing is fixed for today.
18.
Yes, along with item number 18.
Which one item number?
18, 18.
1 is.
Yes, 18.
It's supplementary, no? How do you excellent. Okay, so, yeah, matter is
Item number 18, Ray Tagam versus State of Arunachal Pradesh.
what do you want? Adjournment.
No, that in item number 18, same alleged accused has filed a subsequent bail application where, yes.
For some time.
Ma'am,
And
I
your
wish
flag.
to mention item number 13, ma'am.
13.
Yes, ma'am. This matter may be adjourned for today and same may be list after 4 weeks. ma'am. I am the respondent in this
You are
case.
the respondent.
Yes, ma'am.
The appellant,
I have taken question from the appellant.
you taken consent?
Yes. Again, in my lord, item number 14 and 15, ma'am.
14 and 15 also.
Yes, ma'am.
MSc matter.
Yes, ma'am. Same may be list after 4 weeks. ma'am. Okay, much obliged.
Sixteen. 16.
Mark,
Yes. Repeat.
my lord, lease after 3 weeks. My lord, my submission is, my lord, necessary correction will be done within 2 or 3 days. So later, this matter may be listed after 1 week now,
After 1 week.
1 week. Because my lord is, see, if I'm not mistaken, my lord, the direction of court is that I have to make necessary party to the father of the informant, my lord. So that will be done within, my lord, within this week.
After 1 week.
All right.
Yes, 17.
My lord, I am on behalf of the petition. So here, in this matter, we are praying for the quashing of an FIR that has been registered under section 120V, 153A, 195A, and 134 of the IPC. My lord, this On the face value, if we take the FIR, no such alleged offense has been committed, my lord. The whole issue, it has been raised only to wreak vengeance upon the petitioner
Charge
because.
sheet has been submitted now.
uh,
Charge sheet has been submitted.
Yes, my lord. So at this stage, we may be allowed to issue notice to respondent number 2 and 3.
Okay, sir. So and so learned now for the petitioner, now at PP. Hearing for the street, respondent 1. It's an application under section 482 CRPC. In connection with, what's the case number? Let's say you have mentioned this police station case number. Charge sheet has been submitted to.
Lordship,
Yes,
it's
ma'am.
investigation stage, Lordship, only
Yes.
FIR, passing of the FIR, Lordship.
Only FIR.
Yes, my lord, only,
Charge sheet has not. been
no,
submitted
not been submitted.
In connection with, Ying
Yungkyong police case.
Case number 2922 under section 120B, 153A, 295A. Plus 34 IPC. Issue notice to the respondent 2 and 3 with the registered ID. As well as issue the process returnable within 4 weeks. Petitioner is take steps within 7 days. Call for the case diary.
Scan copy of the case study.
Scan copy.
Yes, Lord.
Scan copy of the case diary. List the matter. 4 weeks.
Lordship.
Deeply
Yes,
overlooked.
Lordship.
1.
May I please your lordship?
Yes.
Lordship, here I am appearing for the respondent. Actually, what has happened? I had a talk with the respondent and the respondent told me that if it is a matter that is pertaining to a civil dispute, then he is ready to settle. But here the background is as such, lordship, that one SIT has been formed. And that SIT, they issued a notice to us, a wireless communication. In response to that wireless communication, lordship, we appeared,
My lord,
I am for the respondent,
respondent, my lord. I'm supposed to make a submission in fact before.
my brother Mekan.
My lord, this is an application under 439(2) of the CRPC for
Cancellation.
cancellation of the bail granted to the alleged accused person on 8/12/2022 on a specific ground for the violation of the condition imposed by this honorable court, my lord. My lord, shortly I'll brief the gist of the case, my lord.
Where is the order?
The order is, my lord, page number 11, my lord, of my petition.
11.
Yes, my lord. And the relevant portion would be at page number 12.
12.
1, 2, 3. From the 5th paragraph, may I read, madam? After hearing the learned counsel for the parties and on perusal of the application, this court is inclined to grant the anticipatory bail to the applicant by making the order dated so and so absolute under the following condition. The applicant shall appear before the officer in charge crime branch PSSIT, Police Headquarters, Itanagar, Arunachal Pradesh on 15/12/2022. The applicant shall not tamper with the evidence of the investigating agency or prosecution witnesses. The applicant shall not leave the jurisdiction of officer in charge PSSIT, Headquarters, Itanagar, Arunachal Pradesh without prior permission of the officer in charge concerned. However, whenever such permission is sought, the official status of the applicant and the responsibilities connected therewith shall be taken into consideration by the concerned officer in charge as and when such permission is sought for. Violation of any of the above condition will automatically lead to the cancellation of this order in the event of arrest of so and so, madam. Since there is a specific direction by this honorable court that the applicant shall appear before the officer in charge crime branch SIT on 15/12/2022. As of today, my lord, neither this order has been executed nor, my lord, they have
It did
cooperated
not
with it.
appear before the.
Never appeared, ma'am, till today.
Yes, please.
Now may I? Now, lordship, here,
CD, huh?
I have
It
the
is
status
received.
report, ma'am.
no, they are never producing the case diary. Now let me clear it up, lordship. What has happened? SIT has started an enquiry. Lordship, I am specifically on enquiry. And when this bail petition was considered, they also produced before a status report regarding an enquiry. Now, in connection with an enquiry, I cannot be arrested, Lordship. For arresting, there has to be an FIR. There is on today, till today, no FIR.
No, if I was.
There is no
Inquiry
FIR.
still is under inquiry.
Yes,
And
so how can I,
on the basis of the
Let me
WT message, they have filed an application before this honorable court under 438 of CRPC, which was allowed by this honorable court.
no, I'm.
But
coming to
however,
that.
there's a specific direction, my lord, to appear before the investigating officer,
No,
which
I-
has not been complied with, my lord. Now, we are not on inquiry or the FIR, my lord. Whether the order of this honorable court has been complied by the accused or not, my lord, since there's a clear violation of the condition imposed by this honorable court.
No, now let me please come. Have you completed? You have anything to submit? Yes. Okay, no, no, please, then you submit. Lordship. So please make a lot of submission, then I will submit. Your submission complete.
I'll brief the fact of the case, man.
My brother has completed his submission, then I would like to
I
submit.
will make.
You make a submission? Okay.
So apparently you have violated the order of this.
Now, let me submit, Lordship.
Yeah.
15/2/2022, he was very sick, Lordship. He could not appear.
Any
So
medical
now
document?
we asked for an extension and my brother is
Any
not,
medical document?
no,
You have
Lordship.
submitted?
No,
Then,
I'm submitting, Lordship. Now, thereafter, when we filed one quashing petition before this honorable court, this honorable court allowed us to appear. We could not at that point of time also because some his marriage solemnization, everything was going on. Now, the question that is before this honorable court, Lordship, I have been told that there is a civil dispute going on. And in case of that civil dispute, we are ready to make good the compensation that they are looking for. But we want to know what is the amount. Actually, what happened, there was one gas plant, a gas agency set up. There was a contract between this so-called informant, I don't know who is the
I
informant.
can
Lordship.
understand,
Yes.
your point.
So now we are ready to pay good the amount of money. But
No,
they,
That is not, you have filed the petition for 38 CRPC.
Lordship,
And on the basis of your petition, the order was passed. You
Lordship,
have asked to appear before the. court.
Lordship, Lordship.
Then you
Lordship.
have violated the petition.
So we are always ready to appear, Lordship. There is nothing as such. We are always ready to appear. If your Lordship just,
1 year,
It's been,
almost 1 year.
yeah, one.
yes, because
You
Lordship,
did
will-
not appear.
Yeah.
Lordship will kindly see, that was a
So yes,
space.
that matter will be disposed of.
Yes.
Cancel the bill application.
My lord allows me, I'll place some authorities for the,
Yes.
I'll place some authorities, my lord. in the court.
In that case, Lordship, I would just like to pray with your Lordship, that since it was a specific date fixed,
Oh,
so if,
definitely.
if,
Within 7 days or 7 days.
Yes,
specific
yes,
date was
yes.
fixed. You,
no,
you have
not,
asked that.
not within 7 days or
Even-
something like that. It was 15,
Yes, this
15, 12.
specific date, that
So
is
now
not
if your
bar.
Lord-
It is a conditional bill, no, for 38.
I agree,
So
Lordship.
that is not a bar.
Now, if your Lordship fixes a specific day, immediately will appear. Because we want to settle this off.
At this stage, there is no question of further appearance, so that is fine.
No, sir, bless you.
As your Lordship please. Deplorable.
Free. Huh? MSC appeal, MSC appeal, no?
Yes, Your Honor.
देखो.
Lordship, may I?
Yes, please.
Lordship, I file an IA. For,
IA?
yes, sir.
IA? It is not IA. Where is I?
Yes, Lordship. For striking of my name, as the respondent number two.
The respondent number two.
Yes.
Respondent number two, New India.
Yes, Lordship.
You're for the insurance.
Yes. In the influence judgment, in the influence judgment, Lordship, the insurance
It is the owner. Award was
On for the petitioner, Your Honor.
award was
Applicant.
against the owner.
Claimant.
against the owner.
Yes. Appellant is the owner. The insurance policy was found to be forged and fabricated. Lordship.
Where is the judgment?
Judgment is page number 20 of the main appeal. Page number 15, it starts from page number 15. The operative person also will be at paragraph 4 of page number 2,
Page number 39.
page number 16, paragraph 4.
What is the discussion that owner was asked to pay the amount? Where is?
There is a page number 18, paragraph 9.
No,
The of the
judgment,
yes of the
judgment. In the judgment, that is. Para number?
para number 9, page number 18.
Your Lordship, there is a stay on the judgment given.
Page number 18.
Yes, page number 18.
What is this? The facts of the case award? That is different.
Lordship, the firstly, the compensation award was, the liabilities was fixed against me. Thereafter, Lordship, I filed a review petition, which was allowed by the judgment. Yes, it was.
The vehicle was not insured, no, at the relevant time.
Yes, and Lordship, in the appeal also, the relief they are seeking is not against me. There is no relief.
The owner is to pay the amount.
Yes.
So, striking out, any objection from your side?
No, Your Honor.
Third, Mister. in IM in Central Learned Council for the petitioner representing insurance company.
Yes.
And Learned Council for the petitioner has filed an application stating that the award, the compensation was awarded in favor of the opposite party claimant. And owner was directed to pay the said amount as the vehicle was not insured at the relevant time of the incident. As such, the petitioner applicant, that is respondent number 2, in MSA appeal number 4/AP 2023, we strike from the area of the respondent. The Learned Council for the respondent claim has made no objection on the plane of the petition. So the name of a respondent number 2. Of the petitioner is by striking of the name of respondent number 2 in the array of the respondent in MSA appeal number 4 in bracket AP 2024. Registry is directed to the NIPCO. IS stands discussion.
Bibliography.
And in the main which respondent number 1, that owner, no? Respondent number 1 is.
Yes,
owner.
sir. Yes, sir.
You have taken steps against owner,
Not yet, Your Honor.
not yet.
We'll take the steps.
In the main MSC activity, Mr. Swainsu, Learned Council for the appellant, issue notice to the respondent number 1 with registered ID as well as usual process returnable within 4 weeks. Steps be taken within 7 days. List the matter record.
Understand.
Main and is still young. Nineteen, this is 19. I see. This is main university order taken. Main university. I will do the order for you. You do the order. You do the. People doesn't. People revision petition. Huh? It. It. Item? This item? 80. 80. 80, no? Deal.
Yes, for last order updated city. And here's the medical report of the inmates. opinion, I have put a paper mark. He's suffering from psychosis and referred to mental hospital, Midpur.
Refer to mental hospital.
Yes,
Psychosis and schizophrenia.
and advised to review at Trims Hospital, Nalagan. As I submitted on last occasion also, she is the prime accused here, firstly. Second, her, at this stage, her releasing on bail will greatest impediment for investigations to further make out this, establish the case and to arrest the other absconding accused also. Stolen properties or crore of rupees, these are antique pieces which this already arrested accused were stolen on the BS, on the instruction of this accused, these inmates. Now, medical report suggests that she is suffering from some mental illness and advised to go for treatment in mental hospital. My prayer before this court would be, Your Lordships, there is a provision for under 439 that temporary bail may be granted till the treatment of the accused. And the hospital authority of the mental hospital may be directed as when she become normal, then it may be informed to the police officer so that further investigation may carried out. That is my humble prayer. And this offense involved the heinous offense 413, habitual recipient of the stolen property, that is punishable punishment which extend to life imprisonment. Yes, of course, there's a provisions for temporary bail arrangements to the accused who is suffering from ailments.
So,
4 cases she is wanted.
no,
57(3)(8). The section.
No, 413.
413 is added.
Yes, it is there.
if my friend submission is over, then may I, Lordship? So this was fixed for medical health report. My Lordship kindly peruse that medical report. On 9th September, she was diagnosed as schizophrenia by the medical officers of Julie Jail, and same subsequently referred to Naharlagan Trims Hospital. And on same day, she was diagnosed as psychosis and referred to mental hospital Midpur for further treatment and to be informed to the family member. But Sam has not been informed to the family member. And the causes for this schizophrenia and psychosis main causes are, in the instant case, on 26 August, she was arrested at late night, and all her ornaments, personal ornaments were also.
What are stated that schizophrenia?
Yes.
That is not mentioned in this report, only
Yes.
mental psychosis.
It's
Only
there. I will.
have a psychosis. Schizophrenia is totally different issue.
So if you see the report of this last page, medical report last page,
So only one page, no?
may I share this? All the document has been collected from this JMFC. So there is a forwarding from this medical officers of Julie Jail, where initially she was diagnosed as schizophrenia. So I don't know why that has not been forwarded to this.
Not in the record.
So may I have that copy, certified copy? May,
Report is here. but
yes,
There is a senior medical health officer. So there is.
where there is handwritten, where it's clearly,
He is the jail doctor?
Yes,
Jail.
jail doctor.
one is jail doctor and one is TRIMS government medical office. So even though after release of bail also, she will definitely move to this mental hospital only for treatment. So she will be admitted over there. So there is no such things that she will absconding somewhere or something like this.
Is provisionally diagnosed to have the psychosis, not much more. And the present complaint that is backache, running nose and unable to stay at gym. That is your reason that she is unable to. stay.
Yes, my lord, even for this signing of this authority letter and regard,
She was referred to psychiatrist at TRIMS Naharlagun for necessary management on 9th, where she was diagnosed to have psychosis, only psychosis.
Yes, and she's already under medications.
so
It's under medication.
at present, she needs family care especially, and she may be admitted at a mental hospital, Midpur.
After proper diagnosis at DREAMS, is that hospital, if it may not be required to take into mental hospital also.
No,
And if mental hospital require her and her to be admitted at hospital mental, then temporary bail can be arranged by this court.
my lord, before that, it's need
Till
to
the
be
thing
need to be understand the chronology of the incident, how custodial assault has happened to her, that alleged accused. That Sam has been perused in that bail application, and that has been also reflected in the observation of learned judicial magistrate first class, and against this hearing officer, there is inquiry being set up at SP level by the learned judicial magistrate first class. So the causes for this mental trauma and everything is because of custodial assault. Based on that, judicial magistrate has given custody to Julie jail instead of this police remand. So meanwhile, there are subsequent this sworn arrest application are there against this alleged accused by stating that there might be prima facie case against her, just for investigation and just to harass her, just to weaken the custodial complaint. That Sam has been reflected in bail application.
To answer? Narrative counsel for the petitioner and narrative additional copy for the state respondent. The petitioner has filed an application under section 239 CRPC. Being for granting bail. The alleged of accused petitioner, Rick Amar, in connection with Naharlagun case number 136/23 under section 480, sorry, 380, 411, 413, and 34 IPC. It is submitted by learned counsel for the petitioner that the petitioner has been detained in custody since
25 days.
when she was arrested,
26 August, it's 25 days.
25 days. In jail now, yeah.
And all statement has already recorded.
She is suffering from schizophrenia and mental disorder. It is also submitted that per order of the learned CJM. CJM,
JMFC, Learned Judicial Magistrate First Class.
JMFC, UPR,
Yes.
that The petitioner has been tortured in the custody. As a result of which, Learned Magistrate has noticed some injuries on her person when she was produced before the magistrate. As a result of which, her police custody was denied and she was sent to jail. It is further submitted that the articles which were recovered from the possession of the accused petitioner, not petitioner, petitioner is his brother, no?
Yes, alleged accused.
Alleged accused belongs to him, belongs to her.
All has been recorded in her residence CCTV footage during arrest period.
And it appears from the CCTV footage that the two other persons, two other accused, no, were involved in the alleged offense of committing theft in the house of the informant. So under such grant, the bail may be granted to the petitioner. Next, on the other hand, in response, on an additional petition, has submitted that the accused petitioner is the receiver of stolen articles. And more than half of the stolen property were recovered. Stolen property of the case has not yet been recovered. As the accused petitioner had sold it off to various people who were being identified with the help of the accused. If bail is granted at this stage, she would cause an impediment to the to further recovery of the stolen articles. Learned additional people also pointed out that as per medical report, the petitioner, the son of petitioner, the accused, alleged accused is diagnosed to have a psychosis. And she's under medication of a psychiatrist of Trims Hospital. Trims Hospital, Naharlok, no? Trims Hospital.
Diagnosed by Dreams Hospital, but still,
Naharlok.
yes, still in judicial custody.
She is a habitual offender. And at this juncture, she may be allowed to take treatment in mental hospital in the district under police protection. The bail may not be granted at this stage. I have considered the submissions of Learned Counsel for the parties. These verses, peruse the same. Where is the Caesar list you have stated on that day?
Seizure list is not there, recovery memo only. But
That's fine.
on the disclosure made by accused herself,
That's,
disclosure statement is also there.
Only
On the
disclosure.
basis of disclosure statement of the accused.
Disclosure. Where is it?
Statement. That paper plate I put in horizontal. So disclosure statement of the accused.
Is a recovery.
Yes, there's a disclosure statement and on basis of that recovery memo. And even the seizure of the vehicle, Scorpio was done on the basis of the disclosure statement that from where the red bag containing this antique pieces of ornaments were found.
That's why, my lordship, all has been recorded in her residential CCTV footage. That's available with PS. IO.
This court
And
during the
that-
bail matter may not act like the mini trial. This main basis of the bail principle reiterated in many cases by
Since
the Honorable
there
Apex
is no proper seizure list also, just they had just seized all personal ornaments and the personal property. That also same has been acknowledged to this on learned court on previous day bail hearing. Just mere presumption that she has bought some stolen property, but all ornaments has been seized, her personal ornaments only. And this, most of those inflicted shown arrest has been done just to weaken the custodial complaint. Still, inquiry report is awaited, which was supposed to be submitted on 14 August.
It is scissor memo. So one scissor memo is there, but Pakum Goda.
Yes. There are two disclosure statement and there were two discovery memo. One made by the co-accused, Tapum Godak, one by accused herself. And modus operandi of this case is that she is the main instructor, main prime accused who used to modify the original antique and thereafter sold it out to, and that bank account. I have no objection regarding the temporary bail.
That was
Yes.
not that lady.
Yes, there is
Two discovery memo, two disclosure statement.
Disclosure statement is.
Disclosure statement, two disclosure statement. Previous to main accused here, previous to that case,
The Rikiam. He just stated it will go to comment.
and two disclosure discovery memo.
On the basis of discovery, that is disclosure statement.
Yes,
Then some things were.
recovered.
Where is recovery?
That is a discovery memo there.
Where is it?
There is just a paper like also there.
Various.
Two disclosure statement, two discovery memo. Under section 27A in the evidence.
So from whom it was seized? That is not there. A residence of Tapung Goda.
No, thereafter resident of
That's why resident of
disclosure made by Tapung Godak and discovery, it was led by Tapung Godak to the place, this dwelling place of the present accused instead of.
Residence of Vidyam. So up to 67 items,
Yes, more than that also.
papers related. So you have not produced any documents that you have purchased those items.
my lordship, regarding, that's why everything is recorded in her own residence CCTV footage that is within the custody of Naharlagan PS.
Those articles.
Yes, and regarding, yes, lordship, regarding article,
You have
it-
submitted any documents that you have purchased those articles from
That-
someone else?
that's why, my lordship, regarding those ornaments, local ornaments, there are numbers of replica. Same replica, you will find millions of pieces within in Itanagar, in market. So that's why
You don't have any documents.
there won't be any document, my lord, for everyone, especially for those local ornaments, because there is no such type of MRP, means proper business system. Just most family, they keep with them for, especially for marriage, marriage ceremonies.
The amount, the price of this article about more than 1 crore.
Definitely, even for alleged accused also, that ornaments and those local dowry, everything,
What is she is doing?
she is a business lady.
Business.
Yes,
Any trade license, anything else?
trading license.
Anything else she is doing any business?
She is especially she does local business with these local traditional beads. So just there is allegation that she has received or bought stolen local beads. Mere suspicion only, she was arrested on 26th of August. Subsequently, there was a custodial assault and same was,
So I have heard all these things.
Yes.
I don't have such.
so at this juncture,
Please, you don't have any documents or anything else?
on humanitarian ground and medical ground, my lordship may consider being a lady, she, and even,
Treatment with the, under police protection.
that's why that medical treatment should be done on 9th of September. but still not informed to the family member. So,
Family member, they have the.
my lordship,
PP.
so just to weaken the custodial assault, just they are trying, keep on just shown errors repeatedly. Same thing is going on. Just to harass this lady on the alleged accused.
This is your petition.
Yes.
Your petition.
Yes, para 11,
Para 11.
page 5 of 8. Down below page number is there. Page 5 of 8.
Okay.
Uh,
Then it.
This is a very infamous Papu Yadav case where incarceration period was not taken in consideration while granting bail also. And simultaneously, Your Honor, nature and accusations of the severity of punishment. In the case of conviction, nature of supporting evidence, reasonable apprehensions of tampering with witnesses or apprehension of threat to the complainant, prima facie satisfaction of the court in support of the charge. That is a three ingredients of this judgment is already present in this instant case. So I have no objection regarding the temporary bail while she is on treatment. But after she getting normal, then
Treatment, under.
My lordship, under the treatment is not going on. That's why this bail application and filed. So may grant interim also. And after that,
Okay, in support of his submission on an additional PP. Has relied on a case law. You can see it now, 2006, volume 8, Supreme 874. CBI through the partisan. On basis of case diary, it reveals that I has collected sufficient incriminating materials against the present petitioner. After recording the disclosure statement of the accused, not petitioner, accused, not petitioner, accused. The articles were seized from the residence of the accused, Uri Kama, amounting to rupees more than crore. According to learned counsel for the petitioner, she is a businesswoman dealing with selling of goods. But no any document is available in the record regarding business. Regarding doing of business by the accused, like trade licenses, etc. No any document is also available in the record that he has purchased such articles from any shop. Showing his belonging to the articles. In view of the above, and then trying to run bill to the petitioner. However, for 1 week or 2 weeks,
my lordship,
Yeah.
may one minute because treatment is needed. That will definitely with strict bail condition and we will be abide by it, and Sam will be in mental hospital only. At least for one.
treatment in the hospital, no problem, but
Yes.
police protection. So
No,
bail is rejected.
no.
Better if bail is rejected.
My lord, please may consider for 1 week also, my lord. My lordship,
However,
my lord, for 1 week that will do.
the jail authority is directed to produce. Provide proper treatment to the petitioner, to the accused. In any psycho, any hospital, any mental hospital, like TRIMS or
Mid-pu, yes,
Mid-
mid-pu, my lord.
Of
My
the-
lord, my lord may consider please for 1 week because the family member, she needs family care only at this point. My lord,
You can file a petition before the CGM.
I'll oblige.
File.
CD may be written.
CD, return back.
Yes, maybe.
Service report in respect of respondent 1, 3, 4, and 5 are still awaited. So this is an appeal against the acquittal filed by the state,
Fill against it.
acquittal.
Section 5.
The 5 is also there, man.
190 days.
Yes, man. But in this, service report in respect of 1, 3, and 5 are still awaited, man. So we'll wait for some more time. ma'am.
So many respondents, no?
Yes,
Not
Yes,
yet written. Still awaited. So await or you
Yes,
have to
madam.
take- await.
ma'am.
But Planet BP. For the state appellant. Await service report regarding respondent. List the matter after 3 weeks.
So, give your-
Lordship, the service report is still awaited with respect to respondent number 2 and 3.
For the insurance, no?
Yes,
1 and 2. Await service report, 1, 2 and,
2 and 3.
or 2 and 3, sorry. 2 and 3. What about 1?
One,
Already
Mr.
done?
Yes,
1 is the claimant.
yes, one is the claimant.
1 is the. But is appealer. Then at least for respondent 1. Respondent regarding respondent 2 and 3, await service report. List the matter for 3 weeks.
Plus,
Number 7.
Lordship,
Section 5,
Section 5 of Limitation Act,
how many days?
68 days.
70 days. That's what we did.
As per prayer, your honor, it is 70 days.
70 days. yes,
But in the
70.
course title, it is reflected 68 days.
It is
It
corrected.
is,
It has been corrected. 70 days.
70.
You have objection?
yes, my lord.
You have submitted your objection?
Yes. I have filed affidavit in opposition.
Little bit in opposition.
My lord, may I? The ground of delay, why I have been delayed. Your Honor, my lord, first of all, this is a ex parte judgment. Ex parte judgment case. So, meaning thereby I was not aware of the case. The previous council did not convey the matter that under what stage the case was going on.
You didn't receive the notice earlier?
That notice was actually not exactly handed over to me.
according to their statement, that they have delivered the notice to one of my close friend. At the meantime, I was about to leave for a Guwahati for some official work. So that was on the day of
What are the grounds you have stated in your petition? In which para you have stated? So,
I would, let me, my lord. In para number, page number 4, para number 4,
para four.
yes, para 4. Yes. It is stated that one keeper of Romyang, who happens to be my close friend, that they have delivered the notice to me.
Is a government servant? He is a government servant.
No,
Then where he is working?
pardon?
Where is he working? Where he is working?
No, he is not working. He is resident of here only, UPR.
You have stated so, no, in your petition, in your.
Official work with some
what
personal office,
work?
some personal official work.
You are not working anywhere. What type of official work?
Kind of official work means to meet some official staffs of Guwahati or Delhi, something like. So the problem here is, my lord, that they have stated that 28/11/2009.
That is not satisfactory. You are not working anywhere. So what type of official purpose you are visiting on that during that period?
I have, my lord, I have clearly stated that how long I have been there, and when I come to know that the ex parte order had been passed by the learned court below, and then thereafter immediately I filed a miss case for recalling of the ex parte order, but unfortunately that was dismissed by the learned court below. So here in this case, my lord, there is some sort of miscommunication between me and my previous counsel. Previous counsel never disclosed the things which is going on and in what cases, the stages of the case actually. And then, as I have stated, and when I came to know that the ex parte order has been passed by the
You have such contradictory statement because the case was proceeded ex parte.
yes,
So you don't have any knowledge about. it.
I was not when I
You
came.
have stated here that you have received notice.
No, this is their allegation that they have hand over this Kipa Kromyang is not me. This is one of my friend. This is not me.
You are
I'm
Tang.
the Tar Tugum. I'm Tar Tugum and Kipa Kromyang happens to be my friend. And then they have stated that I have delivered
He received notice on behalf of you.
he might be, but at that point of time, I was in hurry because I was about to leave for a Guwahati, and thereafter 2 days I had there at Guwahati, and immediately thereafter on 1st December 2019, I left for Delhi. And I stayed there for Delhi for more than 1 month, and I have enclosed the.
So you have not communicated with your friend, that is the present petitioner. regarding issuance of receive.
No, 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 no. He did not convey anything to me. Because he might have received the copy, but he did not disclose anything to me. So then when I came back from Delhi, thereafter, I came to know that the ex parte order has been passed by the learned CGM. So immediately thereafter, I led my counsel to file a miss case. That is on 6/11/2022, but it was dismissed by saying that there is no appropriate ground to condone the miss case. So then thereafter, what happened? And then again, me as appellant file a civil revision petition by CRP, civil revision petition number 05/2021 in this Honorable High Court, and it was again dismissed on 04/10/2021. Then due to non-afference of the prosecution.
You are not.
This is what I'm trying to satisfy this court, that my counsel, due to the recklessness and carelessness of my counsel, number one, he did not convey the case about the case, and number two, he never appeared. Sometime he will appear, sometime will not appear. So in this case, the ground of dismissal of my IA on the CRP number 05/2021 was that non-appearance of the prosecution side. And then again, then this case number 01/2021 for restore and recalling of dismissal order dated of 0/10/2021. And this Honorable High Court, accordingly on 26/10/2021, case was restored. But again, the previous counsel, what happened, my lord, again, my previous counsel, that on the case was fixed for hearing. In what ground that the condemnation should be considered. On 28/04/2022, it was fixed. And again, my counsel failed to appear. So accordingly, the same was dismissed. Same was dismissed on the ground that by non-appearance of the prosecution side. On that 28/04/2022, that the opponent counsel apprised this honorable court that in the main case of money suit 96/2019, that the judgment has been already passed. So meanwhile, the already non-appearance of the prosecution side was there. At the same time, the main case of this money suit number 96/2019 judgment was already passed by the learned CGM. So matter was in praxis. In that way, the matter was dismissed. So thereafter, and then again, we have filed. Again, after the matter was in praxis, since the matter was already passed its judgment by the learned CGM. So we have filed the IA in the Honorable Court of District and Session Judge.
Yes, you have filed one affidavit in opposition. Where is it? It is in opposition. Yeah. The fault
So
of
as
they have
Lordship-
stated that I can understand that is the fault of the lawyers, previous lawyer.
yes, exactly.
Yes, please.
My lord, the ground taken by the applicant, appellant is only that the he could not contest the case because of miscommunication of his counsel here. So, Your Lordship, this is a ex parte proceeding. The question of miscommunication of the learned counsel does not arise, Your Lordship, because this is a ex parte proceeding. The applicant was very much aware of the case that the suit is pending before the learned court below against the appellant. So he was very much aware of that. And Your Lordship,
Anyway, not much more, only 70 days.
yes, it is 70 days, but Your Lordship, there must be a reasonable ground to interfere this court, by this court. And the appellant must satisfy that there was a reasonable cause and sufficient cause. But in this case, present case, Your Lordship, the appellant, the applicant is failed to establish a reasonable cause. So that's this honorable court can interfere, Your Lordship. So is very failed to establish any reasonable cause.
But it's a ex parte matter, no? It says one chance should be given to the other side to contest the matter. That is why it's a money suit, no?
Yes.
ma'am.
Lordship, in the appeal, the page, may I take Your Lordship to page 132, 132.
132.
Your Lordship, appeal,
In the main suit.
yes, main appeal.
One 32,
32, Lordship.
132, yeah,
Yes, 132. Yes.
order 9 rule 7.
Yes, this is the misapplication filed by the applicant. So in this, Your Lordship, may I take to para 2?
Para 2.
Yes. May I read you? That the defendant humbly submits that he has received the dusty notice served by one of the close friend of the plaintiff, Sri Kiparubnyam, somewhere in the last part of November 2019, but he has not opened the letter and had rushed to Guwahati for some urgent official work. Again from Guwahati, the defendant has gone to Delhi. On 1/12/2019, the defendant reached Delhi and checked into the Northeast Lodge at Safragan Enclave, New Delhi, and stayed there in Delhi till 18/1/22. Your Lordship, they have admitted that they have received, the applicant has received a notice. So he was very much aware of the suit. So despite of receiving the notice, he did not participate in the proceeding. So this is an admitted fact, Your Lordship.
They stated that he has no knowledge because the notice was served to the friend, to his friend.
Exactly.
Not served to the friend, Your Lordship, served to the appellant,
The
applicant.
notice served by
It is clearly, Lordship mentioned Kiparubnyam.
friend.
Yes,
Kiparubnyam.
a close friend of the plaintiff, Your Lordship, not the applicant.
Okay. Yes.
Despite of receiving the notice, he went to the Delhi, he went to the Guwahati.
That friend has gone to Guwahati and somewhere else.
No,
Not the petitioner, the petitioner.
Yes, applicant gone to Guwahati and then Delhi after receiving of the notice. Only he had stated that he did not open the letter So this cannot be the ground, your lordship.
Because I was in hasty, man.
Your lordship, after,
The grounds. is-
during the pendency of the suit, the applicant has filed a CRP before this honorable court, and it was also dismissed by this honorable court on non-prosecution, your lordship. So he was very much aware of the case pending before the learned court below.
My lordship.
Yeah.
Lordship, as I have stated that this honorable court has dismissed the matter twice, but however, it was restored once. And then again, my counsel did not appear. On that ground, the matter was dismissed. And then later on, we have filed the civil revision petition here at District and Session Court. But due to lack of pecuniary jurisdiction, that matter has been
This has been served by you, by the petitioner himself, as per order dated, order of the civil senior division.
Yes,
That is why the suit was proceeded expertly, not your friend, which was
That-
duly received by the defendant.
It cannot
In
be.
the appeal, you were the defendant, no? In the, sorry, in the title suit, you were the defendant there.
yes.
Yes.
Defendant Tar Koyu, no?
Tar Koyu.
Yes, Tar.
Two.
Saying that affidavit of service has been filed by Kippa Robiang stating that he has personally served the notice to defendant on so and so. So thus the motive affidavit is there, definitely.
Yes,
There is signature of the parties also. So the ground you have shown that is not good.
But lordship,
The
in support of my, submission, I have a ruling. Lordship.
Ruling, what is?
Lordship, there are so many rulings. I'm praying for only 68 days, which I'm relying on this Supreme
There
Court.
is so many, if the grounds are reasonable, so
Res-
you can consider the matter.
yes.
The grounds you have shown that is not considered,
Here,
because
It
you
is-
have telling a lie. You are
no,
telling a
Lord,
lie.
no, Lordship.
As per thus the mode of service, you have received the notice.
Yes,
No, Lordship.
As per report of the, I don't know, that is the order of the civil just senior division.
yes,
The same that affidavit of service has been filed by so and so stating that he has personally served the notice to defendant
yes,
on 28/11/19. So
Yes.
that's the mode of service. The report is not with us. So at this stage, I cannot say. So if you believe on the statement or order of the civil judge, so notice has been
This-
served.
That I was very much on his submission that on that point of time when this Kippa Robiang came to my house, I was in hasty. I was about, as I have stated, I was about to leave for Guwahati. So the many people come and go. Sometimes people come bring a envelope and for kind of donation, some kind of invitation, so and so. So at that point of time, I was not at all aware of the fact that there is a money suit or case against me. So I was in very hurry. So and thereafter from Guwahati to Delhi, I have clearly enclosed the memos also where I have stayed there at Delhi. And then regarding my relying on this Apex Court judgment, that the Apex Court have even condoned 4,644 days.
To because there is also, if it is
What?
reasonable, you can
Yes.
consider the matter.
4,000, 3,000 days.
Yes, yes, no problem. Definitely the grounds are reasonable. They have shown the reasonable. ground.
In my case also, Lordship,
The grounds are not reasonable. We have not shown properly.
this all happens because of my previous counsel, Lordship. If my previous counsel could have appeared,
Notice personally, the matter was proceeded ex parte. What
Yes.
counsel-
is, however,
Blame the council, no?
Your lordship, council cannot be fixed liability because the proceeding was ex parte.
Service of notice. Service of notice is also there, that is
Yes,
on 20/12/19, as per the order of the civil judge. One hearing notice was satisfactorily served on the applicant, defendant. So you're telling a lie. that
no,
you
Lordship,
have not. Definitely,
yes.
no, Lordship.
document says so, no?
Documents that the friends of,
That appeared for the petitioner also.
they could have served me personally, but they have,
That is a dosti mode of service. Definitely he had received the notice. Today also. the notice is called the non-appeal. When that is civil revision petitions and dismissed. Revision also dismissed, you are not appearing.
this,
Because of his non-appearance.
this judgment and decree order also came to know from the opponent counsel. Opponent counsel,
I'm satisfied with the submission, but if he has no objection, I don't have any problem.
No, your, no,
Because
I
if
have
it is
an
70
objection.
days, you can.
The applicant
grounds
must
are-
establish a reasonable ground to interfere with this court.
Sir, that are not reasonable. So
ground is, Lordship, my ground is that number one, I was out of station at that point of time.
Is it after receiving of the notice?
Yes.
That is not, you have not received the notice. You have received the notice on the same mode of service. That is clear from the evidence, the statement of the, the order of the civil judge.
Even.
That was their allegation.
Miss case, your lordship.
Yes,
Even
this case
the
also
miss
he
case,
has
he,
not appeared.
the applicant himself have admitted that he had received dusty service notice.
Whether everything depends on him, whether you have any objection or not, then we can.
Your
consider.
lordship, I have an objection because despite of receiving,
Okay, I'll pass on. Any other issues? Please.
highly obliged.
Eight.
Lordship, Mayor. Also, I'm yet to file the affidavit, Lordship, with regard to the dusty service. Upon respondent number 2 and 3.
Served properly?
Lordship, we haven't served yet. However, I've sent it to the office, the branch office.
2 and 3, no?
Yes.
2 and 3. So that's the note. So you have not served,
Not yet served.
the place for time.
Yes.
But this is where, so run council for the decline petitioner. Who pays for time to issue notice to the respondent to entry to the same mode of service. Prayer is allowed. Is to take steps accordingly and up to service. Submit the affidavit on this regard.
Lordship, notice has been already issued. Just the copy is not served yet.
Already issued.
Yes.
So you have not filed the affidavit.
Yes, I'm yet to file the affidavit with regard.
Please for
Service.
time to file it.
Yes.
Okay. Just like file affidavit on the same mode of service. How much, 2 weeks time?
Lordship, 4 weeks time.
Four.
Yes.
4.
Deputy office.
It please your lordship. So it's a condonation application. On the last date, Lordships was pleased to issue notice. My lord, we have taken steps. My lord, this is the consignment, track consignment report from India Post, my lord. The registered post has been served on them.
Delivered.
Delivered, my lord.
Yeah.
I've taken it out yesterday, my lord. Condonation of 61 days delay, my lord.
Civil matter.
Civil, my lord. It's a suit for declaration, my lord. And
What
therefore,
are the grounds of delay you have stated?
my lord, I was unwell, my lord. I have given the certificate, my lord, of the Tomoriba Institute of Medical Sciences, my lord, the TRIMS hospital here in Naharlagun. If my lord comes to page 11 onwards,
Page 11.
page 11 onwards, these are of the Government Medical College, here. That's Tomoriba Institute of Medical Sciences. From page 11 onwards, my lord.
So you are taking treatment
I-
during that period.
Yes, my lord.
Good. Case number, nothing is there, no?
My lord, this is in the office court record. It is there that I took the number from the brief, my lord, of the court's record. The postal memo is there, my lord, in the record, my lord.
How can you compare with this with?
My lord, that number is there in the beginning, my lord. In the track consignment, my lord will see even details for RE number so and so. Postal memo to us at all. Record of postal memo to us. Even on this.
Number.
My lord, in the postal memo, my lord will find the number. Postal memo of the notice being sent from this honorable court, my lord. No, this one. No, it won't be. Ask him. Just ask him. It could be like this. Could it be taken just after? I'll confirm from the office where that postal memo they put it here, man. Usually it should be stuck there. I'll just confirm from the office. If my lord takes it up after the next item, I'll just confirm from the office where that postal. I have taken a copy, my lord, but it has to be there in the record.
It's not there.
My lord, that's, I'll confirm from the office, man. Just after the next item, my lord. Deeply obliged.
Your lordship, I'm for the petitioner. I'm for the petitioner and I have already taken steps upon the respondent through court registry post. Yes, your lordship.
You have not taken steps, no?
No, I did,
No, the office note reflects that
yes, but it
you
is
have not
signed.
taken any steps.
Yes, your lordship, that's, then your lordship, I humbly pray I may be allowed to take fresh steps.
Admits to also learn a counsel for the petitioner. And prays for some time. To take steps. Against the sole respondent. Prayer is allowed, the petitioner is to take steps through service of notice to the respondent with registered ID as well as usual process returnable within 4 weeks. Steps be taken within 3 days. This the matter according to.
Deeply organized.
Criminal revision petition.
May I, Lordship?
Yes.
Lordship, kindly, this matter may be action for today, Lordship. My senior, Mr. Pang, says health is not well today, so he left the court, Lordship.
Here for the respondent.
Yes, Lordship.
Respondent. It's a criminal petition, no?
Yes,
Yes.
Lordship.
Revision
Revision.
against the order of the magistrate.
Yeah. Here conviction is only for payment of fine, not imprisonment. Payment
So you
by
are not
6.
ready to argue the matter today?
Lordship?
You are not ready to argue the matter today?
No, Lordship.
Why not? After 7 years, 15, that is pending since 2015.
Yes, Lordship. Lordship,
Yes.
my senior, Mr. Pang's health is not well today, so he left the court. I am for all the respondent, private respondent, Lordship.
All the respondents,
Yes, private respondents.
5 respondents. It's a small matter. you can't
It's a
just
very,
force-
very clear case. 313 is all admitted that they have trespass, they have dismantled. And there is no punishment for imprisonment also, only for payment, because on their admission only, under 313. Very simple case. Clear case.
427.
Yes,
Only
427. Yes. Read with 34.
Want to drag this matter in this way, you know, the 7, 8 years.
Lordship, I am for the petitioner. Although this matter is of 2015, however, the earlier conducting counsel, he expired. After his expiry, this matter has been engaged and endorsed to us. So recently only we could collect the documents. So this matter may be fixed after Puja break, so that because even the petitioners are from Tawang. So we could contact them recently, all the appellants, the revision petitioners.
Third case, sir. So Lana for the petitioner. Lana Reddy, CP and Lana counsel for the, you for the respondents,
All the private respondent.
private respondents.
Yes, Lordship.
Lana counsel for the private respondent, submits that. The senior counsel, Mr. P. Punching is out of nation and pays for served back to argue the matter. Lana counsel for the petitioner also has made an objection on the prayer of the petitioner as he has been newly engaged in the matter. So considering the condition, the case is adjourned for the day. List the matter after 3 weeks.
Sure.
Nine.
My lord, it's in the second file, in the court's second file. I second file.
Second file.
Yes, this one, my lord.
That is the postal memo, my lord.
So this is the number.
Yes, my lord, that man.
Track it, no? So matter with it goes now.
My
Hey,
lord,
man.
I dismiss.
Hard business, to learn it counsel to the petition. And a case for the respondent. Only sole respondent.
Full respondent, my lord.
It is submitted by learned counsel for the petitioner that as per track consignment, the notice has been properly served to the respondent on 15/8, no, 15/9,
My
15/9/23. This is an application for section 5 of the Limitation Act 1963. Praying for condonation of delay of 61 days in filing of the connected appeal. Against the interim judgment. An order dated 16/23 passed by the London Civil Judge, Senior Division, Upper Subansiri District, Dapo Region, in title suit number 1/2019. Learned counsel for the petition submits that the petitioner was suffering from in which disease he was taking treatment during that period.
My lord, from page 11, my lord, he was suffering, my lord, from from page 11 onwards in Tomoriba Institute of Medical Sciences, my lord. He was advised to avoid long distance traveling or driving, my lord.
You're suffering from
My lord, back,
heart problem,
my
heart disease. He was asked not to travel.
my lord, back disease, not heart, my lord.
Back,
Spondylitis. basically. If I understand it, it's intervertebral disc bulge at L4-5 and L5-S1. My lord, page 15,
as per
page 15, my lord.
page 15.
My lord. This is a typed copy. Photocopy is in page 14, my lord.
I think the question, Miss Tanya
Sri, my lord.
suffering from disc bulge, intervertebral disc
Disc
bulge
bulge.
with recurrence of back pain and she, no?
He, my lord, he. My lord,
Yes.
tick mark over Sri, my lord.
He is Tanya Raji, your petitioner is not
Tanya Raj,
Tanya Raj.
Tanya Raji, my lord.
She's lady, no?
No, my lord. His Sri, male, my lord.
Tanya Raji, okay.
My
And he's taking treatment at Trims
Trims.
Hospital, Naharlagun.
My lord.
And he was advised to take rest in between stress work and avoid long distance driving
And traveling.
and travel. As a result of which he was not in a position to attend the court in time. And as such, there was delay of 61 days. In support of the submission, Learned Counsel also submitted some documents, medical documents regarding treatment of the petitioner. None has appeared on behalf of the respondent to make any objection against the prayer of the petitioner. Considering the submission and the background of the case, the prayer of the petitioner is allowed and considered. The delay of 61 days is condoned. Case is registered, no?
No, my lord. It needs to be registered, my lord. Oh, they have registered, my lord. RFA 5 of 23.
As the case has already been registered, is the matter for admission.
But notice,
I stands disposed of
but in the RFA, my lord, notice has to go, my lord. In
for
the,
admission.
my lord,
No? Number is there. so
number is there. So, my lord, notice,
Already registered.
yes, my lord. Notice may be issued in the RFA, my lord,
That on the first day.
on the first, my lord, my lord. My lord, could I pray for a date, my lord? If it is
Date
date
for admission.
for admission.
1 week.
Or my lord, could it be on, if it is not inconvenient, my lord, on 16th of October, my lord?
16.
My lord.
1/6.
1/6, my lord. Deeply obliged.
Well,
May I please, your lordship? It's a appeal against conviction. Yeah,
want to
lordship,
come to the matter today.
it's up to your lordship. It's up
I
to your
don't
lordship.
have any problem. We can take up the matter to Guwahati and make the judgment.
Otherwise, lordship, this matter is of 2017. I will definitely leave it up to your lordship whether your lordship will, because today lordship here, there are 15 witnesses.
15 weeks.
So here lordship will kindly see if your lordship take up page number 35 of the paper book. Let me see how much I can address this honorable court today. Because lordship, why I'm submitting so, page number 35 will show that the two appellant before lordship has been convicted under 352 for 2 months and 448 and 34 for 5 months and fine. Page number 35 of the paper book. Your lordship has kindly got it, lordship.
35. right?
35 of the paper book. So that speaks of the order, that is the operative portion of the judgment where the sentence has been.
35 is the recording deposition.
No.
Paper book. Yes,
No,
yes,
I'm sorry, not the paper book, the judgment. Because in my paper book, the judgment was not so clear. So I've been furnished a separate copy of the judgment.
Okay, so the judgment is here.
Judgment, in the judgment, if your lordship kindly take up page 35.
Page
35. In internal page 35.
35. Page 35 is the
35 of the internal of the judgment. So if your lordship has kindly find it that they have been convicted under 352. One of the appellant has been convicted under 352, Nagit Ayyo. And both Nagit Ayyo and Riza Melo has been convicted under 448 and 34. Now, 352, lordship, I'll just read out. 352 says that punishment for assault or criminal force, otherwise there's a grave provocation. Now, the law relating to 352, lordship, will kindly see whether provocation was grave and sudden enough to mitigate the offense is a question of fact. So that is why I will have to read out the evidences, lordship. Whether the evidences will prove that this was done out of a otherwise than a grave provocation. If there is a provocation, then perhaps 352 will go. And if there is no provocation, that is otherwise than on provocation, then 352 may follow. That means the conviction will be right enough. So the lordship will kindly see here, there are 15 numbers of witnesses that prosecution has relied. Before that, lordship will kindly see the FIR. The FIR
in paper book.
In page 1, lordship, of the paper book. Page 1. The time is a factor in this case. Therefore, I would like to lay some emphasis on the time of the LS time of the LS occurrence. It says, Lordship as such, today at around 6:45 PM, I had just returned from my office and changing over my clothing in my bedroom of official, it will be residence. My maid servant, Sri Vijay Sonar but Vijay Sonar is a male, although written maid servant, was just lighting the bulchari. Just then suddenly Sri Nagvit Ayo, followed by Sri Rijam Malo, rushed into my bedroom with a dao, kicked my maid servant down to the floor and charged at me with the dao. I had to defend myself by catching hold of the dao. Hearing the commotion, my younger brother Sri Nani Ubin rushed to the room, tried to pacify Sri Nagitayo to throw the dao which he was holding. I tried to convince them to put the dao inside the cover and proceed to the common room to discuss if any matter for which he had come. Meantime, Sri Rijam Malo was standing by, also pulled out the dao hanging on the wall. The dao belongs to me and rushed at me. Somehow we had resisted and they fled the spot, taking my personal dao also. And sir, it is a pure act of attempt to murder as in a clear manslaughter intention. So the person concerned must be immediately arrested and brought to book. So this is the allegation in the FIR. Now, your Lordship will kindly see, he said that the incident took place at 6:45 PM. Now, next page is the 154 format. Lordship will kindly find that
Case was registered under.
case was registered under 452, 352, 506, 34 IPC.
So magistrate tribunal.
Yes, yes. No, 302 was there, but 307 was there, but 307 we have been acquitted. No material was found. 307.
Submitted.
Yes.
Charge
Charge sheet was, I'm taking your Lordship to the charge sheet. Charge sheet was also under 307. And Lordship will find it is there in 304 is there, page number 10, Lordship.
10.
The last portion. Hence, under the above circumstance and from the statement of witnesses which corroborated with the medical document, PM examination report, a prima facie case under section 452, 352, 506, 304, 426, 34 IPC is found well established against accused so and so.
304, not
304. Sorry, not 307, 304, because one person died. That 304 we have been acquitted.
Okay.
And till today, there is no appeal against that acquittal of 304. Which at least we have not received any notice in regard to the same. So the judgment that has been passed in that respect of acquitting us under 304 has attained its finality, Lordship. Now, Lordship, may kindly once again please come back to the FIR for a moment of time. It is 154 format, which is a little bit of importance for us. Your Lordship will kindly find in 3A. I'm in page number 2, Lordship.
So somebody died.
Somebody died. I'm clearing up that also. Who died and how he died.
Okay.
Okay. So Lordship may kindly come to page 2, 3A.
2, 3.
Page 2.
Page 2. Yeah.
Page 2. Now the paragraph is 3A. Occurrence of the offense, day is Wednesday, date from 27/10/2010, date to 27/1/2010. The time period is 1845, time from 1845 to not known. Information received 27/1/2010 at 20:30 hours. That means he said it happened at 6:45 and the FIR has been lost somewhere around 8:30 on the same day itself. There is no general diary entry reference number, entry is nil, and the GD has also been made at 8:30 hours. Now, the charge sheet I have already shown your Lordship, already seen the operative portion of the charge sheet. Charge has also been accordingly framed. And Lordship may just come to the depositions because the depositions are important.
Framing of charge, where is it?
Framing of charge, I will take your Lordship. Take your Lordship, it will be. Charge with 3 heads, that is in page 1 itself.
Page one.
It is showing like this only. No, 32, Lordship, page number 32. 32. It says, may I just read it out, Lordship? Your Lordship can kindly find it. 32, Lordship. First, that it is charged with 3 heads. First, that on or about 27th day of January 2010 at about 18:45 hours, you committed house trespass by entering into the house of Sri Robin Nani, executive engineer, with preparation to cause hurt to Robin Nani, and thereby commit an offence punishable under 452 of the Indian Penal Code within my cognizance. Secondly, that you.
452.
No, it has been, in fact, 452, it should be
Thereby
447. But they have written it 452. 452, yes, page 32, I am on page 32, Lordship. 452, Lordship,
Yes,
I kindly see.
452, yes.
House trespass after preparation for hurt, assault or wrongful restraint. So that is under 452, first charge is under 452. Then Lordship may kindly see, secondly, that you on or about 27th day of January 2010 at about 18:45 hours at Anani, you both assaulted and used criminal force against Robin Nani, executive engineer, and his maid servant, deceased Biren Mizar. So Biren Mizar, he expired.
Yes.
And thereby committed an offence punishable under section 352 of the Indian Penal Code within my cognizance. 352. That is hard cause, otherwise than on grave provocation. That you on or about 27th day of January 2010 at Anani, you both committed criminal intimidation by threatening Sri Robin Nani, executive engineer, PWD, with an injury to his person, and thereby committed an offence under section 506 of the Indian Penal Code within my cognizance. Now, although they have written it three heads, Lordship, but I find that there are 6 charges. So the form may be wrong anyway. Charge being recorded under a wrong heads will not affect the prosecution case. That law is settled. I am not on that also. That
What is 426? 426 the penal provision?
426, Lordship, it says
Maybe 427 is the penal provision.
427 is a penal provision. 426 says punishment for mischief. No, it's a penal provision, Lordship. 420
For?
mischief.
Oh,
Mischief. And now I'm coming one by one, Lordship. 506 I have already read out. Then fourthly, that you on or about 27th day of January 2010 at about 18:45 hours at New Anani, both of you committed murder by intentionally causing death of Bire Mizar and thereby committed an offence punishable under section 302 IPC within the cognizance of the Court of Session. So there 304, they are treating it under 302 because charge sheet was never under 302, it was under 304, but the court has charged me under 302. That you on or about 27th day of January 2010 at Anani, you both committed mischief by causing wrongful loss or damage to the property of Sri Robin Nani, and you have thereby committed an offence under section 426 IPC and within my cognizance. Sixthly, that you on or about 27th day of January 2010 at 18:40 hours at New Anani, you both Nagit Ayu and Rijam.
That is
34.
34, not separately. That will not.
No. But
That is wrongly.
whatever it is, Lordship, what is now, I have been convicted under 452, 447 and 34. 302 I've been acquitted. Now, Lordship, I have just read out that I have been convicted under 352, 447 and 34. Now 352 says, Lordship, that whether provocation was there or not, mitigation was there or not, it's a matter to be affirmed from the facts. So therefore, I am taking your Lordship to the statement of the witnesses. There are 15 number of witnesses whose statement has been recorded. I'm reading it out. Lordship may kindly have a look. It is from page number 33.
33, yes.
33. PW1. PW1, Lordship, was the driver of the informant. May I just read it out, Lordship? Since this driver, he was the driver. Since December 2008, I've been working as casual driver at Anani. On 27/10/2010, at about 18:30 hours, I dropped Sri Robin Nani, executive engineer. Lordship, Robin Nani is the informant in this case. PW at his official residence from the office. I handed over, took out the briefcase from the vehicle, called his Kancha, namely Biren Bijay, and hand over the bag to him to drop in sir's room. Thereafter, sir asked me to bring the audit party from the office dinner. There are some small grammatical mistake. We are overlooking all these things. When I reached gate for went out, I met both the accused standing on the dock in the gate. They are coming on motorcycle and stopped my gypsy and asked me where about my EE Sahab. Now, Lordship, here one thing to be noticed. At this point, when they first met the accused in the gate, they are not saying that the accused is carrying any weapon with them. Driver is silent because driver is the person who first met them in the gate. They simply asked, where is the executive engineer Sahab? These two person, Lordship, happens to be, these two appellant, happens to be casual worker, that is Khalasi, under this informant. That is my instruction. And that has probably come in the evidence also. I told them that I have just dropped my Sahab at his home. On this, they asked me to call Sahab. I told them that I have just dropped my Sahab and now I have to go office to bring audit party. If you want to go and meet Sahab. At this, they shouted at me, "Maar khayega kya?" Then I went back and called Biren loudly. In the meantime, I was trying to open the door. The accused pushed me out and went straight inside the house. Suspecting some problem, I followed the accused up to dining table. In the meantime, Biren also came out from sir's room after lighting Bukhari and asked the accused if they had any work. At this, accused Maipi Tailu slapped Biren, saying that "Tum choro." Thereafter, I left the room and came out running. And when I reached up to the vehicle, the other officers also reached by then, and I was narrating the incident inside. After about 2 minutes, we all heard the gunshot. Now, Lordship, here, Lordship will kindly see that they were not carrying any weapon. So where from this gunshot came? This is important. We'll have to find it out, Lordship. And one more thing, if I may kindly submit here, Lordship may kindly see that on that day, there was a small party, dinner party arranged by the informant for the audit party. That is admitted that there was some party out there. Thereafter, I along with J.E. Taba Sahib went to police station to inform the matter. When we reached PS, police has got the information already. Then we went back to the, this is very important, Lordship. When we reached the PS, police has got information already. How did the police get the information? In the 313 statement, the accused stated that they have lost the FIR first. So it may be a case of cross FIR. That I will show you, Lordship. It is in the 313 statement. He has got the information already. Then we went back to the resident along with police who were in the police vehicle. When we reached the resident, Biren was lying on the floor. Therefore, they do not know how Biren was lying. He was lifted in the police vehicle. He took to the medical on the same night. We left for Dibrugarh medical on the next morning. We reaching Rohing. We went to Rohing medical also for taking first aid. And thereafter, we reached Dibrugarh in the evening. Biren was admitted in Aditya nursing home where after 2 days he died. So he might have died for not getting proper treatment because they were roaming with him. Thereafter, he was taken to AMCH, Dibrugarh for postmortem. Dead body was handed over to us and we took dead body to Itanagar. Biren had an injury mark on the back side of his head neck. Police took my statement. Now, Lordship, kindly have a look into the cross by the defense. I have been sleeping only once. Biren fell down on being slept. When I came inside the room, Biren was inside sir's room. I saw accused sleeping Biren from near the dining table, which is in between the kitchen and sir's room. Biren was left near the door when he came out from the room towards the dining side. There was a bokhari and small table, and there was nothing other than that in the room. Thereafter, I came out from the room, and after about or more minutes, we heard round of gunshot. The office party who were present outside were Samir Babu, Pal Babu, Kuti Babu, and all staff around 7 to 8 persons. From Anani, we were boarded in 2 vehicles, one Gypsy and Scorpion. Gypsy was driver by me, J.E. Taba. OP Verma were boarded in the Scorpio. Drivers are complainant. Buddha Mega, deceased person, Biren were boarded. There was no police person in 2 vehicles. That means they were alone. They went alone with the injured person who died on the road. After coming back from the PSI, I saw injury which was on Biren, which shows hole-like injury of blood also could be seen in the injury. The distance between SARS residence and the police station is about 1 hour. I came back to the residence with police within 1 hour. When we came back, all the staff members were present in the SARS room, and I was accompanied with the hospital. That means he was left in the hospital. Then Lordship will kindly see PW2. PW2 is, his name is Lordship. My name is, it's not written out there. Nani Ding is his father's name.
Father's.
It is his father's name.
The
Oh,
first-
Nani Obin. Thank you.
Nani.
Thank you. Nani Obin. Deposition of Sri Nani Obin. I have been summoned by the court to depose in connection with the case where Nagi Tayu and Rijam Melo are involved. This case is in connection with the death person of maid servant Vijay Mijar. They're just confusing. It's not a maid. Vijay Mijar. Somebody is saying Vijay Mijar, somebody is saying Vijay Mijar. I know both the accused person by face as well as by name. The incident took place on 27/1/2010. On that day at about 6:30 to 6:45 p.m., I was present in my room at the residential quarter of my elder brother Robin Nani at Nani. That means this witness is the brother of the informant. Then from my room, I heard one person speedily going towards my elder brother's room. The step was not of my brother's working, so I doubted and suspected to be some other stranger person. Then after a few seconds, I heard the sound of hitting somebody. Then I came out and saw accused Nagvi Tayu giving kick to our servant, late Bire Mijar. At that time, late Bire Mijar was burning local heater, it is Bukhari, near the door. Thereafter, he took out his dao and went inside the brother's room. Then I also followed towards my brother's room. When I reached brother's room, I saw my brother caught hold of the hand of the accused Nagi Tayu, in which he was holding a dao. Thereafter, I saw my brother also holding pistol. So therefore, the informant was holding a pistol, Lordship, in his one hand pointing towards the accused. So informant was fully armed. Then I also tried to snatch away the dao from the accused Nagvi Tayu. In the process, I tried to specify Nagi Tayu and told him that if he has any grievance, it can be solved amicably by discussion. But he did not listen to my request and still asked me, who am I to interfere? Then my brother, Nani Robin, told him that I am his younger brother. Then within 2 to 3 minutes, accused Rijam Melo also came inside the house. As we were already holding the dao, accused Rijam Melo also joined us, trying to snatch away the dao from the accused Nagvi Tayu. In the process, the dao also hit on the head of the accused Rijam Melo. So one of the accused, he got injured, Rijam Melo. At that time, one JE, Mr. Komkor Taba, also came inside the house and have been seen us from outside the room near the door. Thereafter, my elder brother, Mr. Komkor Taba, to call the police after getting injury on his head, accused Rijam Melo left the dao. But I was still holding the dao, trying to snatch away from the accused Nagvi Tayu and continue trying to specify accused Nagvi Tayu. Later on, accused Nagvi Tayu agreed to put back his dao inside the dao cover. So he has put the dao inside the dao cover. So there was no hit by him. Now Lordship knows very well, here the tribal people, it's a tradition that they used to carry the dao because of from the animals and all. So it is nothing unnatural. Later on, accused Nagvi Tayu agreed to put back his dao inside the dao cover. Komkar Taba did not use telephone was dead. I tried from the parallel line telephone in the kitchen upstairs as well as my mobile phone, which was also having no network. When I was busy in telephone in upstairs, I heard sound coming from downstairs, which later on I came to know that it was sound of gunfire. Now, Lordship, just few minutes back, he said that his brother was holding, that is the informant was holding a pistol. So there was a gunfire from the informant's pistol. Then I heard sound of someone running out from the house, then rushed down and tried to see who ran out from the house. But since it was dark, I could not see him properly. These were the appellant. But now they are saying that he could not see them properly. Then I went back to my eldest brother's room inside the entrance of the bedroom, which was partitioned by a curtain. I saw servant Vijay Mijar lying on the ground and my brother was attending him. Then my brother asked me actually what has happened, because all of a sudden the gunshot came. He became frightened and he fell down. That is the observation of the court below. He fell down, and because there was a firewoods nearby, he sustained injury in his head and later on he died. That is the observation of the court below. That is why we were acquitted out of 302, Lordship. I saw lately Vijay Malla lying over the cartoon of the, that is very clear from his statement, Lordship. I saw late Vijay Malla lying over the cartoon of the firewoods and bamboo, which were used for burning the heater. His neck was lying over the cartoon of the woods and the bamboos. If your Lordship has kindly got it, Lordship. His neck was there. So he got injury. Then I saw he was having injury on his left side of his neck and blood was oozing out. It was an injury weapon like bamboo firewood. After some time, my elder brother also came back to the house and we lifted his head from the carton of the firewoods and took him to his room. Then thereafter again tried to inform the police through telephone, and this time the telephone was working and I informed the police accordingly. This is very surprising. 5 minutes back the telephone was not working, but now it is working. Bide was almost unconscious. He was trying to say something which he could not, which we cannot understand. After some time, police arrived and inspected the place of occurrence and also seen that injured Bide was lying on his bed. Then injured Bide was lifted to the medical in police vehicle, where doctor, after checking treatment, referred him to Dibrugarh for further treatment. In the same night, Bide Mijar was taken to Dibrugarh, my elder brother's department vehicle. Now, Lordship, you may kindly see, the driver said that they went to the police vehicle, but he is saying that he was taken by the department vehicle. Anyway, we reached Dibrugarh on next evening via rowing. At about 9:30 a.m., Bide died in hospital at Dibrugarh. Now, Lordship will kindly see 31/1/2010. At 9:30 a.m., Bide died. And the FIR was registered before. So how 304 will come, Lordship, because he has not died. It was, if I am not wrong, the FIR was on 27/10, 27/1/2010. If your Lordship got it, Lordship, kindly. That is why in the FIR, it is 452, 352 and 506. Nothing as such. Later on they added. Now, cross by defense. Robin Nani is my elder brother in relation. I have been posted at Anani since the year 2006. Since my posting, I have been staying in the quarter of Robin Nani. The bedroom of Robin Nani was partitioned into two parts. The heater Bukhari was kept little bit towards right side of the entrance door of the bedroom. The firewood was kept left side of the door in the bedroom. There was about 4 to 5 feet distance between the heater Bukhari and the firewoods. Accused assaulted the deceased by kicks near the heater Bukhari. The deceased fell near the firewoods. On seeing the accused assaulting the deceased, I immediately rushed towards the bedroom. When I entered, here Lordship will kindly see that the accused have no reason to assault the servant. That is, the one who has expired is the servant, because they were always looking for the informant. Therefore, this statement is not matching with the circumstance. They said, from the gate, they said, "Where is Sahab?" So they have no reason to assault him until and unless there were some provocation to them. Maybe out of that provocation, something might have happened. On seeing the accused assaulting the deceased, I immediately rushed towards the bedroom. When I entered the bedroom, I found deceased Biray Mijar was already on the ground. When I entered the room at that time, I did not attend the deceased lying on the ground. I saw him one glance, but I entered the room as Nabi Tayo had entered the room with dao in his hand. When I immediately rushed to my brother's room, by that time, my brother had already entered in his inner side partition of the bedroom. The incident of the assault of Biray Mijar took place in the outer partition of the bedroom, and the incident of the dao was with the accused and the brother took place inner side of the partition of the bedroom. Can that happen, Lordship? They are saying that there is a curtain, and inside the curtain, the incident with the dao happened with the informant, and outside the curtain, the incident happened with the victim who has succumbed to his injuries. When I left the bedroom to inform the police at that time, the accused Nabi Tayo and my brother were inner side partition of the bedroom, while Rijam Melo was in the middle just near the curtain. It was an extended bedroom. Half of its partition was half wall and half of it was with a curtain. From the inner partition side of the bedroom, the deceased was lying in the outer partition side of the bedroom, could not be seen because it was covered by curtain. So he cannot see it. He has just assumed it. Moreover, Napi Tayo was also standing in the middle of the curtain. So if Napi Tayo was standing in the middle of the curtain, Lordship, then he cannot see anything because he is covering the curtain. I cannot say whether the partition wall was exactly half wall or more than half. I entered the bedroom once and came out once when the accused were present. But after that they left, I entered again in the bedroom. When I went out from the bedroom, deceased Biray Mijar was lying on the floor. His head up to the neck was portion over the firewood. At that time, I did not attend Biray Mijar. Firstly, I tried to telephone from the receiver near the bedroom. Somebody is lying there in the pool of blood, and this gentleman is not trying to pull him out. Rather, he is busy with making telephonic calls. It was not working. Then I went to the kitchen, which had a parallel line. I went to kitchen to try from there because sometimes due to problem in another receiver, the dialer tone does not come in the phone. Perhaps there was two curtains, one containing firewoods and other containing bamboo for burning the heater. Now, Lordship will kindly see that he is residing in that house from 2006. And now he is using a word perhaps. So he is not sure. Therefore, this witness is not at all trustworthy. Firewoods are normally kept lying and the bamboos are kept in the standing position in the cartoon. It is not a fact that I am deposing falsely. I have seen the injury received Biray Mijar. It was caused by sharp end weapon. It was a hole type injury. Such injury can be caused by bamboo. It is possible that the injured has received injury by falling on the standing bamboo. Now he is admitting that yes, it is possible because he has heard the gunshots. The entire incident from the beginning till the end was take for about 10 to 15 minutes. Small duration incident, Lordship. During the incident, deceased Biray Mijar did not ask for any help. He perhaps was lying on the same position in the same condition. The sound I heard was like blasting of bomb or gunshot sound. At that time, I was in the kitchen. Later on, when I saw deceased Biray Mijar had already bleeded, blood was found on the floor and there was some blood on the cartoon. The cartoon where deceased Biray Mijar was lying over cartoons, bamboo and firewood. We lifted the deceased from the cartoon floor to his room. The injury portion of the neck was over the cartoon. The deceased was almost unconscious. His body did not move. He was groaning out of pain and I have not seen the place where bullet was seen. When I heard sound, I immediately went out to see who had just ran out and then thereafter came back to the bedroom. And so my brother was attending injured Biray Mijar. At that time, both accused had already ran away. So they have already left. After arrival of the police, they tried to ask the injured person about, but the injured did not tell anything. There was many people present in the hospital when the deceased was brought and given treatment in the hospital. My brother Robin Nani came to hospital later after about 40 to 50 minutes, and I was told that first he went to police station. I know that deceased was referred to Dibrugarh, but I cannot say in which hospital he was referred. After referral, we left Anani at about 9 to 9:30 p.m. We went to Dibrugarh in 2 departmental vehicles. Along with the deceased, there was two driver, one junior engineer, one more staff, my brother, one local person, Buddha Miha, and myself. On the next morning, we took the injured at Rowing Hospital as he became more serious. In the Rowing Hospital, the injured received some treatment and medication, but I do not know who attended him. After crossing Shantipur gate, we were stopped by Assam police for some time. I do not know the reason. Thereafter, on way to Dibrugarh, we took the patient in one government hospital at Tinsukia, from where the patient was lifted in ambulance. I do not remember the name of the hospital. In Aditya Hospital, the injured patient was given treatment and test, including CT scan. There was no police personnel in the vehicle. We brought the injured from Dibrugarh. So they knew something have happened because of their own involvement, and therefore they are trying to conceal everything. Police was not there. They are roaming with the injured person who was so much injured. We reached Dibrugarh on 28/1/2010 evening, and the patient died on 31/1/2010. Had some treatment be given seriously at the beginning, then maybe he would have been saved. In the hospital, the father of the deceased, my brother, J. Kombar Taba, driver, and myself were present till 31/1/2010. It is not true to suggest that I am deposing in order to save my brother. In the photograph shown to me in the court, there is no standing bamboo shown in the cartoon. I also do not see any blood stain in the cartoon containing the bamboo and the woods.
Cartoon or carton? Carton?
I don't think so cartoon, it will be curtain. That is the box containing the bamboo woods. Then Lordship, the statement of the informant himself, PW3. If your Lordship permits me today, I will just try to finish up reading the evidences.
Yes.
Then I will address the points of law on some other day or as per the convenience of this honorable court. The 15 witness, I don't know whether I'll be in a position to complete it today or not. But why I'm saying this fact, Lordship, because of 352, Lordship. Otherwise, the case is absolutely clear. May I just read, Lordship? PW3.
Only three is the other witnesses did not say much more, I think.
No, other witnesses did not say much more, and their evidences are contradictory. Let me, some are even hostile also. Let me just read out, Lordship. I know both the accused person Nabita Ayu and Rizam Melo standing on the dock since the year 2008. So,
We just point out something which is relevant. with it.
Lordship, in that way, I think it will be a little bit difficult because then it is a continuity. And then the continuity will miss. Because it's in a flow, Lordship, which is not, it's coming up in a flow. So if your Lordship just allow me, Lordship. Otherwise, it may not make any sense, Lordship. Lordship, I kindly see now that this
Conviction under section 352,
conviction under section 352, 447 and 34.
447.
Lordship, trespass. Trespass, here also Lordship knows very well. The trespass, it comes from 441, criminal trespass. The definition is there. So criminal trespass says whoever enters into or upon property.
448. It's
No,
448.
no.
Your Lordship. It's
440.
448. Your Lordship.
Criminal, it is there.
352, 440, 54.
448 also says for punishment for house trespass. So the definition of trespass, Lordship will find in 441, criminal trespass. So if I just read the definition, Lordship will see whoever enters into or upon a property in the possession of another with intent to commit an offense or to intimidate, insult or annoy any person in possession of such property. So that is where I am. Whether their entrance was due to those reasons. If those evidence are there, then so Lordship will kindly see one thing, that here the informant is admitting that he knows the accused, that is the appellant, since 2008. First line itself. I know both the accused person Nabita and Rizam Melo standing on the dock since the year 2008. They are not new to him. I am the complainant of the case. 27/1/2010 was the last day of audit inspection. At about 6:30 p.m., my driver Indra Bahadur Vishwakarma. Now it's a new name. Indra Bahadur Vishwakarma dropped the audit team to the Circuit House, and then he picked me from my office and as usual dropped me at my residence. As I have invited the audit team for dinner, I instructed driver to pick them up from Circuit House. Then I entered my bedroom. On the way, I instructed my servant Biray Mizar to light the Bukhari. While I was changing my dress, suddenly I heard tap hitting sound from the outside. Then I leaned towards my left side and saw accused Nabit Ayu and beating late Biray Mizar. But Biray Mizar was with him. He was in the room. I saw Biray Mizar was off balance. Then I saw Nabit Ayu giving kick. Late Biray Mizar with his leg saying, Hato. Then I saw Biray Mizar fell on the cartoon of Bukhari firewoods kept beside the entrance wall. The two such firewoods curtains were kept side by side in my house. Then Nabit Ayu took out his dao and advancing towards me, bed area towards. Then I jumped towards my pillow where I kept my pistol. By the time I took out the pistol, he was already inside my bedroom. Then I pointed my pistol at him and I asked him to keep the dao inside Himri, dao under rakho. Then suddenly he halted as he was already in action. Then my younger brother came out of this room, rushed towards my room and caught hold of him. He tried to snatch away dao from accused Nabit Ayu and saying, dao choro. But accused Nabit Ayu was holding the dao with very firmly with both his hands. Rather, he challenged my brother saying who he was. Then I saw accused Rizam Melo entering my room. My brother Nani Obin asked me to specify Nabit Ayu. Rizam Melo also tried to snatch away the dao from the position of the accused Nabit Ayu, but could not. However, but they never got any injury, Lordship. This is very important to see. They were scuffling, but they did not get any injury. However, during the process of trying to snatch away the dao and pushing and pulling, accused Rizam Melo received dao injury in his forehead. It is otherwise around. Then I saw Kimar Taba, junior engineer, rushing towards my room and I shouted him to telephone the police. He tried from my landline, but most probably failed and rushed out of the residence. The dao was still being held by the accused dao and he put back his dao in his dao cover. Then my younger brother left the room towards the kitchen. Then I asked both the accused to move out from my room. Then suddenly accused Rizam Melo took my dao, which was kept hanging in the wall. All contradictory. If he is having a dao in his hand, again, why he will take the dao that is holding in the entrance door of the bedroom? He took out the dao from the cover and moved towards me. Then I shouted him, pointing out my gun and said, dao kor choro, leave the dao. Then he returned the dao to me. Once he pulled out, then he again returned it. I knew the dao, I threw the dao on the carpet near the bed. Then I again saw accused Nabit Ayu took out his dao, advancing towards me. Then again I had to point out my gun towards him again. Suddenly Rizam Melo rushed towards my dao, which was lying on the carpet. Then holding the gun towards Nabit Ayu, I tried to put up my right leg on the dao, which was accused Rizam Melo was pulling up, but I could not. And Rizam Melo had already picked up the dao. Then when he was trying to raise this right hand with the dao, I tried to stop him by my left hand. When I was trying to stop accused Rizam Melo from raising the dao, in the process of scuffling, accidentally gunshot was fired, which hit towards the entrance door wall, but more than 6 feet above the floor. So he has admitted that the gun was fired by him. Then I called my younger brother Nani Obin and asked him to take care of Biray Mizar and myself and went out to see. But Nani Obin said, if your lordship may kindly recollect, that he did not attend Biray Mizar. Rather, he went to make a phone call. And myself went out to see whether both the accused are still inside the house or gone out. When I rushed outside, I saw both the accused ran out and they have already crossed the entrance gate. Then I went back, my brother and myself took the injured late Biray Mizar and put him on the bed in the next room. Later on, police came to my residence. The injured Biray Mizar was taken to hospital in police vehicle. He is saying police vehicle. The other said in the departmental vehicle. The doctor advised to evacuate the injured to Dibrugarh. Thereafter, when I went to the police station, I saw accused Nabit Ayu giving statement before SP, who was also sitting in the office chair. Then I hurriedly write down an FIR and submitted to SP. Thereafter, we took the injured at late Biray Mizar to Dibrugarh. On the way, on the next morning, late Biray Mizar was also given TT injection at Rohing General Hospital as it was not available at Anand. These are not important, Lordship. He has just said how it has happened. Now, the cross, Lordship may kindly see. I reached back to home from office at around 6:35 to 6:40 p.m. I have not seen from which door the accused person entered in my house, but my driver told me that they entered my house from the back door, from where I used to enter without disturbing my common room door. First, I heard a sound of hitting. When I leaned towards my left, then I saw Bide Mijar, who lost balance, and then I saw accused Navitayo kicking at late Bide Mijar, due to which he fell down in the fire cartons. The said incident took place in my front side. The deceased late Bide Mijar was found lying in a paralytical condition, having cut injury on the left side on his neck. Later on, from the CT scan, doctor told us that he was having cervical spinal injury. I have not seen the accused cutting with a dao to the deceased, but from the injury, it is possible that he might have received the said injury by falling on the firewood. It is true that later on, after the intervention of my younger brother, Komar Taba, entered into the house, the accused put back his dao in his cover. I do not know why the accused again took out my dao and tried to attack me. The reason must be known to the accused. When accused Rizam Milo came towards me to attack me with the dao, accused Nabitayo was standing nearby the door. At the time, I was standing between Bukhari and my bed. At the time, my house servant was lying nearby Bukhari. When Rizam Milo was trying to pick up the dao, I was trying to push him down by shoulder area in order to prevent him from raising it with the dao. At that time, he was half bent position. Rizam Malo was in half bent position. So he definitely was not in advantageous stage, Your Lordship. At the time, I was in a standing position. At that time, Nabi Tayo was towards the Bukhari side with his dao open. I applied lot of force upon Rizam Melo in order to prevent him from raising. Rizam Melo also exerting effort with force to raise his hand, and in the process, only the bullet was accidentally fired. The wall where the bullet hit on must be around 11 feet distance from me. The caliber of the pistol was .32 US made. The wall was made of SPT. I cannot say that the bullet once fired only either stuck on the wall or it will exit from it. The distance of the wall from my bed was about 14 feet. I went to the police station to lodge FIR. From there, I directly went to the hospital. Police came to my residence before I left the Dibrugarh, and within 2 minutes, I left the house of Dibrugarh at Rowing Hospital. We spent about 1.5 hours. I do not know the name of the doctor who attended the injury. No police personnel accompanied us to Dibrugarh. It is true that at Santipur gate, we were stopped by the police of Assam. Our vehicle was stopped at Santipur. I do not know why we were stopped. CT scan was done. After CT scan, the doctor revealed the injury was cervical spinal. The patient was admitted, received treatment in the hospital for 3 days. I also was there at the time. During my stay for 3 days in the hospital, no any police personnel came from Anani in the hospital. After incident, I did not go to Anani again. The IO of this case recorded my statement at my residence at Bandedava. Police seized my pistol and the bullet head from me. The bullet head was found from a carpet near my bed. It was found Dipen Melo of Anani. The bullet must have been reflected after hitting the wall. The wall was pakka and not a steel wall. Now the pistol is in my possession, being released on Jimma. I do not remember the date of the seizure. I do not remember whether any photographs were taken by the police during CT, not the CT scan of the so-and-so deceased were seized. During treatment, of the deceased of Dibrugarh, his father came and he returned on the same day. So police has even not collected any medical documents. Now, Lordship may kindly see.
The doctor was examined.
Doctor was examined. I will come to that, Lordship. PW7, Lordship may kindly see.
PW7.
7. That is in page 50.
Yes.
I do not know the person called Nabitayo and Rizam Milo. In the year 2010, I was at Anani with my husband who was working at PWD. Anani at that time, the name of my husband is Nani Tada. The name of executive engineer at that time was Nani Robin. The incident took place in the house of Robin Nani on 27/1/2010 in the evening between 6 to 7 p.m. I was present in that house. In that evening, there was a dinner party in the house. My house was nearby that house. Therefore, I went there to help the service of the dinner party. I was in the kitchen room. There were 3 to 4 men in the kitchen room. I know of two persons who were present with me in the kitchen room there, Ram Bahadur Sonar and Hari Chetri. Meantime, Robin Nani came to his house. Thereafter, about 10 minutes of his arrival, we heard voice of Robin Nani asking, is there anybody in the house? Then his younger brother Nani Robin came to the kitchen and fetched up a glass of water. Running back to the quarter, we also followed. On reaching the room, we found that the deceased person was lying on the bed. I have seen the deceased was having some blood in his neck. Meantime, police came and victim was evacuated at hospital. She was there. She did not speak of any incident. Nothing, absolutely silent about anything about this appellant being there, nothing, absolutely nothing, Lordship. And she was there, very much there in the particular house. Then in the cross, Lordship may kindly see, yes, Robin Nani is my brother-in-law. I can't say whether Robin Nani had come to the kitchen prior to his coming for fetching water. Within that 5 to 10 minutes, I can't say we all came down to the quarter from the kitchen or not, but we came down in group following Nani Obin. It is true that victim was not lying in the room of Robin Nani. I have heard sound of gunshot at that time, either before or after the incident. I have also not seen anybody coming or going out from that house. The Lordship may kindly see this. This is the most important statement. She has not seen anybody. As I was busy in the kitchen, which is separately constructed from the quarter, I have given my statement to the police, but I've forgotten whatever, how many days police have recorded my statement. Shall we get back after the? Shall we?
At 2.
At 2. Diplomats. So, Lordship, I'll just make it short, Lordship. I'll be now taking your Lordship's attention to those witnesses whom we are mainly relying. Now, Lordship may kindly see to statement and evidence of PW5, page 46. 46. Now, this witness, Lordship, he was the driver. If your Lordship kindly remember that he was there all along. Now he has been declared as a hostile witness. Hostile. So Lordship may kindly see his evidence. I know the person standing on the dock, his name is Namita Ayu. I also know the co-accused in the case, but I cannot properly say his name. In the year 2010, I was at Anani working under Gibeon Melo. I was also knowing the deceased Bide was residing with the EE Robin Nani at that time. One day in the afternoon, on their request, I went to the house of EE to cook some items. I have given my statement to the police, whatever I say. Oh, he's a cook here, but his name is Ram Bahadur Sonar. He's the cook, not the driver. He's the cook. I correct myself. I have given my statement to the police, whatever I have stated to the police was true. And I have given my statement to the police, whatever I know about the case. I have stated to the police that I have not seen anything. It is true that I have stated before the police that on 27/1/2010, I went to the house of Robin Nani as a cook to prepare meal for our audit party to take on that evening. It is not the fact that I have stated before the police that I was in the kitchen and hearing the shouting of Robin Nani. I went to his bedroom. The water glass from my hand was taken away by Obin Nani. It is not the fact that I have offered the water to the victim Bide after the incident. It is also not the fact that I have seen Biren on injury condition and was bleeding from his neck. I have also not said before the police that I have found the blood of Bide near computer of that room. I have also not said the two local boys have beaten the Bide. I have also not said before the police that Bide was taken to the hospital thereafter. P Exhibit 6A is my signature, but I have not seen any seized being done by that police. So he is denying his seizure. Cross Lordship, my statement has been recorded to the police in my house. I do not know the name of the police, but he was a Uriya man. Police have visited to my house twice. First, after 2 days of the incident, and again after 2 thereafter. Police officer was on plain dress, not in uniform. He alone had visited my house, and the same have visited twice my house. Police officer was asking as to why he had not seen the incident because he was present in that house. He means he's saying about himself. So police was trying to find out that why he is saying that he has not seen the incident. Whatever is recorded to my statement with the police, is not my statement. So he is retracting from his 161 statement. Now, Lordship will kindly take one very important witness, that is PW 12, Caesar witness, Sohin Mipi.
Sohan maybe.
Maybe, that is, Lordship is in page number 58. P exhibit 11 by A is my signature. I have put my signature as a witness. At that time of seize of a dhow, it was local dhow belonged to Napitayu. The dhow was already in the police station when I came to the police station along with the accused. So it was already there. The seize was made in the police station. I do not remember, probably it was seized after 20 to 25 days of the incident. So Lordship may kindly see that it was not seized from the place of occurrence. I was not told why the dhow was seized. The seized dhow is not available before the court today. Then another Caesar witness, Lordship may see. PW 13. The accused Napitayu is my cousin. B exhibit 11 by B is my signature. The seizure was done in the police station, which was a local law. Same thing. I go to the cross, Lordship. The seizure was made in the police station around 20 to 23 of February of this year. I was not told why the seizure was made. I have not seen the dhow today before this court. But now one thing is very important, which he has said in his chief. I heard that Robin Nani have shoot his own cookman. What is the only fact I heard in the case? So that is in his chief itself. Now, Lordship may kindly come to doctor who has treated him at Anani, at AMC Dibrugarh. I am making it short, Lordship, so that I can finish it off. He is Dr. M. Saikia, PW 9, Lordship. PW 9. It is in page 54. PW
9.
9. In the year 2010, I was working as a resident doctor at Aditya Hospital, Dibrugarh. In the case, I have issued a death certificate of the deceased person. The name of the deceased person, Biray Mizar, on 31st January 2010. The victim was admitted in the hospital on 20th January 2010. The victim was assaulted, on which there was a difficulty in breathing. The victim was admitted in ICU of the hospital. I cannot recollect now whether I have attended the patient or not. So without attending the patient, he has issued a certificate. PA Exhibit 7 is the death certificate issued by me, available in the case record on this court, and PA Exhibit 7 by is my signature. PA Exhibit 8 is the medical report of the victim of the disease, which was prepared by me and was forwarded to police. There was
Issued death certificate.
death certificate, so there was no cross. Now, the one who did the postmortem report, Lordship, that is who Dr. PW 11, Dr. KB Chaudhary, forensic expert. He done the autopsy on him. So otherwise, Lordship, we have been acquitted of 302. I am just placing this evidence before this court to show that the person who died, he died accidentally. And because there was a gunshot, after which, Lordship, I have read evidence also after this gunshot, the two of the appellant, they have also left the place of occurrence. They also ran away. Now this, Lordship, will kindly see. My opinion to the cause of death was due to spinal shock resulting from injury to the spinal cord As described, all the injuries were antemortem caused by blunt force impact. However, to know the exact nature of injury, opinion of treating doctor is necessary. The injury which I found on the body is sufficient to cause death of a person. I have not found any injury on wound on the dead body which might be caused by any firearms or bullet.
Firearms, no?
Or bullet. That means he died by falling on the firewoods. And if I just show your lordship, there is one photograph, page number 26 and 27 of the paper book. Page 26 and 27, lordship.
26. Yeah.
If your lordship has now seen the firewoods. So these firewoods are sharp and are horizontally in one side. It is the second cartoon shows. So there is every probability that he might have got injury from there. So one thing is very clear, that the prosecution witnesses are not speaking the truth. More particularly, those witnesses who are very close to the informant. And apart from these two, lordship may kindly see, the two person who is there is PW7 and PW5, who has been declared as hostile. And they say that they have not seen any such incident. Just a moment. Just a moment. Yes, PW5. We can just take for a moment of time the statement of PW6 because he treated
PW6.
but I am not relying upon so much because 302 and 304 has already gone.
Conviction of the 352.
352. Yes. So, lordship, if I may, I just want to place one judgment before your lordship. It's a judgment of Honorable Delhi High Court, not of Supreme Court. But here, why I am placing this judgment, lordship may kindly see. 17. That is page number 5.
Para 17.
Para 17. On the other hand, learned counsel for the accused person have argued that there are material discrepancies and contradiction in the statements of the star witness of the prosecution. It is further argued that none of the prosecution witnesses have supported the case of prosecution and there is no cogent evidence laid on the record to prove the guilt of the accused person. It is further argued that there is no independent public witness in the present case apart from the complainant herself, and their testimony being that of interested witness cannot be relied upon. I am on that point. So here also, lordship may kindly see that apart from his brother, nobody is supporting the case of the informant. Nobody. And if we just see, if we just look into the driver, his statement has not been recorded. I did not find if it is there. So when he went out and both the appellant were in the gate, they did not show him carrying any weapon. Lordship may kindly mark it. And in one place, the informant has said that he has taken out the dao from the wall. Dao from the wall. And by that time, when he said that he has taken up a dao from the wall, by that time already tussle has started between them. So there was a provocation. And it is an admitted fact that there was a quarrel that triggered between them because the informant himself, he said that he have fired a bullet. So he will unnecessarily not fire a bullet, lordship. Something was there. So provocation was already there. If we now...
As per medical report, there is no bullet injury.
No. He simply fired a bullet, the bullet has struck the wall. But because of the gunshot, the victim might have fallen down and he sustained an injury. Because apart from the informant and apart from the informant's brother, nobody said that they have seen the appellant to assault the victim.
Two appellants, no?
Two appellants. Because the informant said that he was kicking my
Driver.
maid servant.
Maid servant.
Not maid servant, servant. And his brother also said, but the brother was in the other room. If your lordship now have a look into the, I'll just read out the point of law for one moment of time. Page number 25 is the trace map. Page 25, lordship, is the trace map, sketch map. Now, the incident happened in the bedroom, inside the bedroom of the informant. The lordship can see that it's traced through. There is one old kitchen, there is a veranda, then there is a common room, then there is guest room, then there are two toilets and there is a bathroom. If I have correctly read, because my one is not so clear. And the dining halls are this side, in the right hand side. And if the veranda is in the middle, then in the left hand side are all bathroom. So where the incident has happened, it has not happened in the bathroom. It has happened in the bedroom. That is there. Near the bedroom, there is Obin's bedroom. If your lordship is kindly find it. Obin's bedroom. So there is an old kitchen. So if he has gone to kitchen to take the water and all, then it is not so much of distance. He will know what has happened, what has not happened. So therefore, the prosecution witnesses, they are not in a position to make out a case of 352. I just read out 352 for a moment of time, lordship. Whoever assaults or uses criminal force to any person otherwise than on grave and sudden provocation given by that person. Now, if we just go through the evidences, we will see that moment they entered, lordship,
Yes.
they first were obstructed by the driver. They did not assault the driver. They asked the driver, where is Sahab? They went to his room. Then the servant comes. Servant had an altercation. Servant also, they say that you move from there. So there was a grave provocation. So 352, my humble submission, lordship, will perhaps not be attractive. And now if we come to 448, is the punishment for house trespass. Now, the house trespass has been defined in 442. 42. Whoever commits criminal trespass by entering into or remaining into any building, tent or vessel used as a human dwelling or any building used as a place of worship or a place for the custody of the property is said to commit house trespass. Now, lordship, trespass, criminal trespass is defined in 441. 441 says, lordship, whoever enters into or upon property in the possession of another with intent to commit an offense or to intimidate, insult or annoy any person in possession of such property or having lawfully entered into or upon such property unlawfully remains there with intent thereby to intimidate, insult or annoy any such person or with intent to commit an offense is said to commit criminal trespass. So here there are two limbs. First, moment he enters, before entering, he should have an intent. So mens rea should be before entering. And the second limb says that after entering, you remain there illegally. That part is also important, Lordship. Because they said that hearing the gunshot, they fled away. The evidence said that they have fled away. Punishment, your Lordship may kindly see 448 punishment.
fine.
That is. But there is, Lordship, there is even penal provision also. 1 year. 1 year. 1 year. And we have been given, if I am not wrong, that is 448,
5 months, no?
5 months.
5 months and 1,000.
For 352, we have given 2 months, and for 448, 5 months. So my, if I just close down my submission before your Lordship, that the witnesses who have deposed against me are very close to the informant. So their statement are not reliable in light of the judgment which I have played. And the court below, while giving, passing judgment, convicting me, he has overlooked the admissibility of the evidence of PW5 and PW7. Although the law is settled so far, the credibility of a hostile witness is concerned. The evidence of a hostile witness, only because he is a hostile witness, his evidence cannot be discarded. Because he is submitting that nothing happened. So there is nothing to disbelieve. So my submission is there is no evidence. So therefore we may be kindly acquitted.
May it please, your Lordship. Lordship, as far as the submission has been made, your Lordship will see that the entire fact has been twisted to such an extent that the entire court is confused in this case, your Lordship. If I may first take your Lordship to the FIR, your Lordship, which is at page number 1. Now I may read the subject of the FIR, your Lordship. FIR on attempt to murder me, my younger brother, and my maid servant. The entire submission that has been given is only with regard to the maid servant here. Not a single statements were made against the assault on the complainant as well as against his younger brother. So now there are 3 victims in this entire case, your Lordship, not only the maid servant. Now, if I may take your Lordship to page number 2, your Lordship will see it serial number 2, your Lordship. Serial number 2, Act is of IPC section 452, 352 and 506/34. Now, your Lordship will see that prior to the filing of the FIR, your Lordship, his maid servant was still alive. They had taken him to Dibrugarh, wherein after the treatment, he expired, your Lordship. Therefore, 304, 302 was not implied, 506 was given, your Lordship. Now, if your Lordship will come to page number 4, your Lordship. Subsequently, your Lordship, charges were because one of the victim has expired, your Lordship, and therefore section after charge was charge treated under
section 302.
Yes, 304 and 426 were added, your Lordship. Subsequently, your Lordship will see during the framing of the charge, 304 was changed into 302. Yes. Now the entire case was as per the charge framed, your Lordship. Now I fail to understand as to why these, since both the accused were they were defense witness themselves, your Lordship, why their statements have not been read out. If I may take directly, your Lordship, to page number
330.
defense witness, your Lordship.
Defense witness.
Yes. They themselves has made themselves a defense witness. If your Lordship will come to page number 81. He's the accused in this appeal, your Lordship. If I may read, your Lordship.
Yes, yes.
Being a public, we used to seek some small contract work from the complainant as an EE, which is the executive engineer of the department, and he used to execute the work 2-3 days before the incident of this case. I, along with co-accused, went to the office of the complainant again to seek some contract work. I seek contract work for renovation of my village work, and my co-accused also seek some work in their village. The complainant assured me to give some work in my village, but he was asked me to come back after 2-3 days so that he can check the fund position for the work. On 27/2/2010, at about 10 a.m., I, along with co-accused, went to his office for 3 times, but I did not find him in the office. Therefore, I went to his house with co-accused at 5:30 to 6 p.m. of the evening. But we found the main, your lordship will mark this, your lordship, but we found the main entrance gate was closed. Then I asked the deceased about the presence of the complainant in his house, which was replied by the deceased in positive. I further asked him how to go inside the compound as the gate was closed. Deceased told us that we can come through back gate of the compound. Accordingly, we went to that house through back gate of the compound. We were standing in the common guest room from where the bedroom can be seen. We saw that the complainant in kurta pajama dress was moving here and there. We called him that we came to meet him. His bed cover and the pillow cover was of white color. The moment we called him, he picked up a pistol from his bed and started asking us why we came to his house at this hour by pointing towards the pistol towards us. Meantime, one Obin Nani also came near us and pulled out a dove from its cage, which was hanging in the wall, and attempted to attack us, on which co-accused Rijam Malo caught hold of the dove, and there was a pushing and pulling in between them to possess and dispose the dove, on which Rijam Malo also got injured on his forehead. Meantime, complainant fired a shot from his pistol. By that time, dove was in the hand of Rijam Mala. By hearing the gunshot, we fled away from the scene, but before fled away from we saw that deceased was already fall down to the ground and was bleeding from his neck. The complainant was saying that bullet had hit and called for asked for calling the doctor. While coming out from the room, the dove which was in the hand of the Rijam was thrown away near the badminton court, and thereafter we went out from the area. We came by a motorcycle. After coming out from that house, I asked Rijam to go to his house, and myself went straight to police station and reported the matter to police. At that time, SP, OC, and I of this case were present. I have narrated the incident verbally to them. I was supposed to give the written complaint. By that time itself, I was asked to submit the written complaint during office hour on next date. On next date at about 10 a.m., I submitted the written FIR. I have also given my statement to the police. I came to know about the present complaint on next day when I came to police station to submit my written complaint. We were arrested in the case on that day itself. Later on, after 4-5 days, I came to know that there was also quarrel in that evening in other departments also. I don't remember exactly. Perhaps I knew the complainant for about 5-6 years before the incident of the present case. The color of the pistol held by the complainant in that evening was of black color. Now the cross, your lordship will see. It is not a fact that all the government contract work would be floated tender. There are some work which cannot be given without tender also. It is a fact that I did not submit any written application for work, but it was only verbal. It is a fact that the request was not for specific scheme or work which was sanctioned by the government, nor I can say about the sanction of the government or the fund position. It is a fact that we went to his house with a dove. Your lordship will see. He admit to the fact that he had gone to the house of the victim with a dove, which was with me, as we used to carry the same everywhere. We also entered the common room from the back door as the main door was closed. The distance between common room and the bedroom of the complainant will be about 3 to 3.5 meters. It is fact that the deceased was also outside the room when we entered inside the common room. It is a fact that I have never seen that pistol before the incident in his office or in his quarter. It is a fact that I cannot differentiate the pistol and revolver as such. I cannot say exactly whether it is a pistol or revolver, but it was small arms. It is a fact that we were not hit by that shot. It is a fact that we did not see by our eyes with the hitting of bullet on the deceased. I was present nearby them. Then there was a pulling and pushing to possess the dove. It is a fact that Rijam Milo was not taken to medical for treatment. I cannot say exactly what was the cause of injury of the deceased. That can be proved by medical report of the deceased only. Now, your lordship, through the entire statement of the accused, your lordship will see that even though the front gate was closed of a quarter of a government employee, your lordship will see he was staying in a quarter, your lordship. They have admitted to the fact that they have verbally requested the executive engineer to give them some work. Only verbally, no application. Now they have gone to his office 2 to 3 times. He was not there. So they thought that they'll go to his house. They went to his house. Since the front door was closed in an officer's house, they preferred it through the back door, carrying a dao along with them. Now, when they have carried a dao along with them and also had approached the officer on many occasions to give them some work, Your Lordship will see what would be the apprehension of the officer. Now, if I may take Your Lordship to the page number 20, Your Lordship. Yes. Caesar list. How? Because as per their statement, they did not have the dao, and even the Caesar witness has not stood to his statement. Your Lordship will see. I so and so of Anini PS do hereby seize the below noted descriptive dao on being produced by Sri Nyapitayu. So why was this seized dao in the police station, and the Caesar witnesses have stated that it was already in the police station? Why? Because it was not found from any other place, but when it was produced by the accused himself. Now, with regard to the, if Your Lordship will come to page number 21, Your Lordship.
21.
Yes, Your Lordship.
21, yes.
This is the medical report, Your Lordship. This is the medical report of, out of the 3 victims, this is the medical report of the victim who had expired, Your Lordship. Now, 24, Your Lordship will see. There is injury report of the deceased. They have stated that they have just given a page number 24 speaks about the injury report of the deceased, Your Lordship.
Yes.
And then
function, this is weapon is sharp.
yes,
So this is also not the bullet injury.
no, Your Lordship. Now, if I may clarify to that, Your Lordship. The reason I'm pointing to this injury is, Your Lordship, because one of the victim has already succumbed to his injury, whatsoever the injury was, Your Lordship. The trial court during the entire trial did not find any ingredients with regard to section 302, and therefore both the accused were discharged of 302, Your Lordship. Now the chapter of this deceased closes because this victim, the deceased victim, the penal provision that was put to the accused on behalf of his being deceased, Your Lordship, was 302, later on which was to which they were discharged, Your Lordship. Now, if I may take Your Lordship to page number 33, Your Lordship.
33,
Yes.
PW1.
Yes, I won't read the entire statement, Your Lordship, only to the relevant portion, Your Lordship. This is one of the eyewitnesses, Your Lordship, who had seen the accused trespassing to the compound of the PW1, Your Lordship. Since December 2008, I have been working as casual driver at Anini on 27/1/2010 at about 8013. I dropped C. Robin Nani, Executive Engineer PWD, at his official residence from the office. I took out the briefcase from the vehicle called his Kancha, namely Biren Vijay, and hand over the bag to him to drop in sir's room. Thereafter, sir asked me to bring the audit party from office dinner. When I reached the gate went out, I met both the accused standing on the dock in the gate. They were coming on motorcycle and stopped my gypsy and asked me to whereabouts of EE Sahib. I told them that I have just dropped my Sahib at his home. On this, they asked me to call Sahib. I told them I have just dropped my Sahib and now I have to go to the office to bring audit party. If you want you may go and meet Sahib. At this, they shouted at me, Mar khayega kya? They were already agitated, your lordship will see. Mar khayega kya? Then I went back and called Biren loudly. In the meantime, when I was trying to open the door, the accused pushed me out and went straight inside the room. Your lordship will see the action of the accused. They were already so agitated that they pushed the person and they were straight inside the house. Suspecting some problem, I followed the accused up to the dining room. In the meantime, Biren also come out from Sir's room after lighting Bukhari and asked the accused if they had any work. At this, the accused, Mapi Tayu, slapped Biren, saying, Tum choro. Your lordship will also take this point into account. Thereafter, I left the room and came out running, and when I reached up to the vehicle, the other officers also reached by then. And while I was narrating the incident inside, after about 2 minutes, we all heard the gunshot. Thereafter, I, along with J. Tabbas, I went to police station to inform the matter. When we reached the PS, police has got the information already. Then we went back to the resident along with the police who were in the police vehicle. When we reached the resident, Biren was lying on the floor. He was lifted in the police vehicle and took to the medical on the same night. We left for Dibrugarh Medical on the next morning. We reached Roing. We went to Roing Medical also for taking first aid. And thereafter, we reached Dibrugarh in the evening. Biren was admitted at Aditya Nursing Home. Thereafter, 2 days, he died. Thereafter, he was taken to AMCH Hospital, Dibrugarh for postmortem. Dead body was handed over to us and we took the dead body to Itanagar. Biren had an injury mark on backside of the head. Pros, your lordship. Your lordship will see, I have seen the slapping only once. Biren fell on the floor on being slapped. When I came inside the room, Biren went inside the Sir's room. I saw the accused slapping Biren from near the dining table, which is in between the kitchen and Sir's room. Biren was slapped near the door when he came out from the room towards the dining room. There was a Bukhari and small table and there were nothing other than that in the room. Thereafter, I came out from the room after about or more minutes. We heard the sound of the gunshot. The office party who were present outside were Samir Babu, Pal Babu, Kuti Babu, all the staff around 7 to 8%. From Manini, we were boarded in 2 vehicles, 1 Gypsy and Scorpio. Gypsy was driven by me, Jai Taba, O.P. Verma were boarded. In Scorpio, driver, Sir complainant, Buddha Megu, deceased person, Biren were boarded. There was no police person in the 2 vehicles. We were at Dibrugarh for about 3 days. I was there till the deceased died in the hospital. Sir was also present. Now your lordship will see, he has seen the very initially, when the accused person agitatedly come to the complainant's house, first he abused this person on being afraid of it. He said that the sir is inside the house. They went inside the house, they assaulted the deceased victim by slapping him, and then all the recurs happened. Now, if your lordship, I may take your lordship to page number 35, your lordship. This is the brother of the another victim, second victim, your lordship. This is the brother of the complainant, your lordship. If I may read, your lordship. I have been summoned by the court to dispose in connection with the case where Nyappi Tayo and Rija Malo are involved as accused. This case is in connection with the death of a person, maid servant Biraj Mija. I know both the accused person by face as well by name. The incident took place on 27/1/2010. On that day, about 6:30 to 6:45 p.m. I was present in my room at the residential quarter of my elder brother, Robin Nani at Anini. Then from my room, I heard one person speedily going towards my elder brother's room. The step was not of my brother's walking, so I doubted and suspected to be some other stranger person. Then after a few seconds, I heard the sound of hitting someone. Then I came out and saw accused Nyappi Tayo giving kick to our servant, late Biren Mijar. At that time, late Biren Mijar was burning local heater near the door. Thereafter, he took out his dao and went inside the brother's room. Then I also followed towards my brother's room. When I reached brother's room, I saw my brother caught hold of the hand of the accused Nyappi Tayo in which he was holding dao. Thereafter, I saw my brother also holding pistol in his own one hand pointing towards the accused. Then I also tried to snatch away the dao from the accused Nyappi Tayo. In the process, I also tried to pacify accused Nyappi Tayo and told him that if he has any grievances, it can be solved amicably by discussion. But he did not listen to my request and still asked me to who I am to interfere. Then my brother Nani Robin told him that I'm his younger brother. Then within 2-3 minutes, accused Rajimalo also came inside the house as we were already holding the dao. Accused Rajimalo also joined us trying to snatch away the dao from the accused Nyappi Tayo. And in this process, the dao also hit on the head of the accused Rijamalo. At that time, one JE, Mr. Komkar Taba, also came inside the house and have seen us from outside the room near the door. Thereafter, my elder brother asked Mr. Komkar Taba to call the police. After getting injury on his head, accused Rajimalo left the dao, but I was still holding the dao, trying to snatch away from the accused Nyapitayu and continue trying to specify accused Nyapitayu. Later on, accused Nyapitayu agreed to put back his dao inside the dao cover. Komkar Taba did not use the landline phone which was near the bedroom of my elder brother, but he went out from the house to inform the police. After accused Nyapitayu put back his dao inside the cover, I also went out to inform the police. At that time, I found the telephone was dead. I tried from the parallel line telephone in the kitchen as well as my mobile phone, which was also having no network. When I was busy in telephone and upstairs, I heard a sound coming from the downstairs, which later on I came to know that it was sound of the gunfire. Then I heard sound of someone running out from the house. Then I rushed down and tried to see who has run out from the house. But since it was dark, I could not see him properly. Then I went back to my elder brother's room side. In the entrance of the bedroom, which was partitioned from the curtain, I saw servant Bire Mijar lying on the ground and my brother was attending him. Then my brother asked me to look after Biraj Mijar and he himself went out to look for the accused. I saw late Biren Mijar lying over the cartoon of firewoods and bamboo which are used for burning the heaters. His neck was lying. Leaving apart, your lordship, the rest of which is with regard to the deceased, your lordship will, this same paragraph, your lordship will see the last line. Learned Council has even pointed out this line saying that how can an FIR be filed prior to the incident? Your lordship will see incident happened on 27/1/2010. On 31/1/2010 at about 9:30 a.m., Bire died in the hospital at Dibrugarh. This is the time of the death of the victim accused. This is victim, your lordship, not of filing of the FIR or not of the incident, your lordship. Pros, your lordship, if I may. Robin Nani is my elder brother in relation. I have been posted at Anini since the year 2006. Since my posting, I have been staying in the quarter of Robin Nani. The bedroom of the Robin Nani was partitioned into. Yes, I have. Yes, sir. Now, your lordship will see the evidences, your lordship. He has seen, the other PW2 has also seen that his maid servant was assaulted. He has also seen, your lordship. He has seen the accused coming to the house of his elder brother's quarter and prior to that hitting the maid servant. Now, one of the very important witness, your lordship will see, I won't read the statement of the complainant. Your lordship has already gone through the statement of PW3, your lordship.
PW3.
Yes, he's the complainant who has totally clearly stated that how he was assaulted and how the accused has trespassed his quarter, your lordship. Now, if I may take your lordship to page number 42.
41, then 42.
His name has been taken by PW2 in his statement saying that this person was also present, your lordship. His name is the deposition of Komkar Taba, your lordship. Yes, if I may read, your lordship. I know both the accused standing on the dock. One is Nyapitayu and other Risa Melo. I know this person since 2005. At that time, I was posted at Anini and both the accused used to do works with me at that time. I came here on summon of the court to give evidence in their case. I have also given statement to the police in the case. On 27/1/2010, we have organized a dinner party for audit party in the house of the executive engineer Sri Robin Nani for audit party. At about 6:40 p.m. of that day, I along with three of my colleagues, namely Okupulu, RB Gupta and Opi Verma, went to the house of the Robin Nani. We were entering from the back side of the compound gate. I was the first person to enter the compound. When I reached near the kitchen room of Mr. Robin, I heard his voice shouting that keep the dao inside, then talk to me. Dao andar rakh ke baat karo. That there is some serious problem inside the room. Then I straightly went to the bedroom and I saw that the accused Nyapitayu was holding a dao in his hand and accused Risa Milo was also present. The younger brother of the Nani was also trying to snatch the dao from the accused Nyapitayu. The accused were on aggression mood at that time. When I tried to enter the bedroom, I found that the house servant of Mr. Robin, namely Mire Mitra, was lying on the floor near the door of the bedroom. Mr. Robin then asked me to inform the police. Accordingly, I tried to inform to the police by landline phone, but it was dead. Then I again tried to contact the police through mobile phone, but the line was not clear at all at that time. Therefore, I, along with driver of Mr. Robin, Sri Indra Bahadur, who is the PW1, Your Lordship, went to Anini police station by gypsy of our department. When I reached police station, police has already received the information of the incident and police party was ready to proceed to PO. Then I came back along with the police station to the PO. The deceased Biren was evacuated to the hospital by the police party who was seriously injured by that time. We have also accompanied the police to Anini hospital. After some time, the doctor of Anini hospital referred the victim to Dibrugarh for further treatment as victim was very serious. Then we along with Mr. Robin evacuated the victim to Dibrugarh hospital. Now in this, the statement, initial statement, Your Lordship will see, he has clearly seen the accused holding it down and he was the complainant was shouting that you put the dao back to the cover and then you talk to me. And he has also seen the younger brother of the complainant trying to snatch the dao from the accused person. Now, if I may take Your Lordship to page number 55, Your Lordship. Another important witness, you know.
It is 55 PW10.
PW10, Your Lordship. His name is Buddha Mihu, Your Lordship.
Yes.
I know both the accused Nyapi Tayo and Rija Malo. I also know that then PWD Mr. Robin Nani. After hearing the incident of the present case, I went to hospital at Rowing first and then on request, I also accompanied them to Tinsukia and then to Dibrugarh. When the victim was evacuated in Dibrugarh, I have given my statement to police. At Rowing police station, Rowing hospital, the victim was treated for about half an hour. No, Your Lordship, I'm deeply apologize. Your Lordship will come to page number. Page number 58, Your Lordship. This is the statement of the Caesar witnesses, Your Lordship, which I have contradicted to while taking into consideration the Caesar memo, Your Lordship. Now, if I may take Your Lordship to page number 62, Your Lordship. He was the IO, Your Lordship. His name is Mohan Mili. Witness PW15, Your Lordship. If I may read, Your Lordship. I know both the accused standing on the dock, they are Nyapi Tayo and Rija Malo. I am the investigation officer of the present case. A written complaint was received on 27/1/2010 from one Robin Nanu with a complaint that his maid servant has been beaten by the accused person. On the registration of the case, the then OC has endorsed me the case for investigation. The FIR was received in the police station around 8:20 PM of that evening. Before that, Your Lordship will see the FIR was received in the police station at around 8:20 PM of that evening. Before that, a verbal telephonic information was already received at 7:15 of that evening in our police station from one Nani Obin, which was with regard to the same incident that 2 persons came in their house and attacked the maid servant with dao. The moment the verbal telephonic information was received, I, along with the available police personnel in the police station, rushed to the spot to verify the matter. When I reached the spot, which is the house of Robin Nani, there were lots of people on the query. The complainant told me that these 2 persons, Nyapi Tayo and Reja Malo, came in his house and attacked his servant. They entered the house of the complainant. The incident took place in the room where Bukhari fire heater were prepared. I found the servant Bire Mija was lying on a bed with a cloth covered in his neck. I have tried to talk to victim Bire, but he could not respond. Victim was in a very serious condition and was bleeding from his neck. Therefore, I immediately sent him to the hospital. I found the bamboo piece having pointed end and the firewood in the place of incident. I have also seized the cover of the local dao. I was told that dao was taken by the accused. There was lots of blood in the floor. I have not collected the blood. Meanwhile, OC and SP appeared in the spot. I went to the hospital along with the OC and the SP to see the victim person. At hospital again, I tried to interact with the victim as per my queries. The victim introduced himself as Bire Mejar, also disclosed the father name and his permanent address, but thereafter again, he did not interact with me. When I tried to ask about the incident and the person who attacked him, then the victim was referred to Dibrugarh Hospital at Anini. The victim was attended by Dr. Saga Migri. Then we came back to police station before leaving for Dibrugarh for treatment of the victim. Nani Robin came in police station and lodged the FIR, written FIR in presence of the SP and OC. Then the case was registered against the accused. Both the accused were arrested on 28/1/2010. I've also seized the dao on being produced by the accused. Now, if I may take your lordship to page number 68, your lordship. This is the 313 of both the accused. Lordship. Page number 68, your lordship.
Okay.
Page number 68, your lordship will see on the upper side, it's written examination of accused person under 313, your lordship.
Only denial.
Yeah, only denial. Your lordship will see there is no specification of. If I may take, your lordship will at page number 72, your lordship.
72,
Your lordship.
yes.
Question number 50, your lordship will see
50.
50. Your lordship will found question number 50, your lordship.
Yes.
By that time, his younger brother Nani Obin appeared in the room and caught hold of you, accused Nyapi Tayo to snatch the dao by saying leave the dao. What do you have to say, both of you? Obin Nani was present, but there was no snatching of the dao, meaning thereby that they admit to the fact that PW2, who is the brother of the complainant.
Examined together.
Yes, your lordship.
How is it?
Your lordship, this format, your lordship will see normally if both the accusers are there, your lordship, they are examined in a no. Your lordship will see they are not examined together, your lordship.
This is not 313, actually, in fact. Anyway.
Your lordship will see like question number 50, they admit to the fact that the presence of the victim, the complainant's brother was very much, he was present during the snatching of the dao, your lordship. Now, if your lordship will come to page number 76, your lordship.
76.
Yes. Question number 92, your lordship will see.
92, yes.
Yes. Sohan Mipi deposed before this court that he had given his signature as a witness in his result list by which a Idu local dao stated to be belong to Nyapi Tayo was seized at police station. What do you have to say, both of you? It is true. Now, since the dao was deposited by him, produced by the accused itself, even they admit to the same, your lordship. Your lordship will see at page number 77, your lordship. Question number 99.
99,
Yes, your lordship.
99, yes.
Lordship will see, he also sees the local dao stated to be of yours, Nyapi Tayo. What do you have to say, both of you? That dao was belonged to me, Nyapi Tayo, but I have not used that dao. Now, if I may take your lordship to page number 85, your lordship.
Page number?
85, your lordship.
85, yes.
Yes, your lordship will see. This is the deposition of the other accused, your lordship. If I may read, your lordship. I know Mr. Robin Nani, the then executive engineer of PW Department of Panini. It was on 27/1/2010 at about 5 p.m. Both of us went to the house of Mr. Robin as we could not found in his office on that day despite of our two visit. When we knocked the door of the house, the domestic servant of the Mr. Robin came out and opened the door. On our query, he told us that Robin is available in the house. When we entered the house, we saw that Robin is running here and there by holding a pistol in his hand. After,
Same thing.
no, your lordship will, this is if I may continue, your lordship.
Okay.
After seeing us, he pointed the pistol towards us and was asking what we want from him. Meanwhile, Nani Obin also came running with dao in his hand. I caught the dao of Obin. When I was trying to snatch the dao, in pulling and pushing, dao hit me on my forehead and blood came out. Meanwhile, Robin fired from his pistol, which hit the domestic servant of that house and fell down on the ground. I've seen the blood was coming out from the neck of that person. When Mr. Robin was shouting that the person was hit with bullet and was asking to call the doctor, then I snatched the dao, and thereafter both of us rushed out from that house. I threw the dao near their gate. Then Nyapitayo went to the police station to report the incident, and I went to my house. We went to his house earlier occasion also, where we asked Nyapitayo to visit again him to see if he can give some work in their village. Therefore, we visited his house for that purpose. We heard that Mr. Robin was in the party celebration of MLA during daytime. Therefore, we visited him in the evening. We went to his house for personal work. Now, if I sum up my entire evidences, your lordship will see the intention. The intention is very clear, your lordship. They had previously, the executive engineer has already given them work on the previous occasion too. Now, subsequently, they wanted some more work, and therefore they had visited him on many occasions. On the date of the incident, they visited in his office for 2-3 times, but they could not find him. Subsequently, what they did is they went straight to his house carrying a dao. Your lordship will see any prudent person for any official kind of one would carry a dao along with him to visit an officer's house. While visiting, as soon as they found the driver, they assaulted him, verbally assaulted him. They entered, they verbally assaulted the maid servant. Then they assaulted the complainant as well as his brother, your lordship. Now, if I may, only to certain aspect, your lordship, if I may read the proviso again, revisit the proviso again of assault, your lordship. 351, which says, 351 says, whoever make any gesture or any preparation intended or knowing it would be likely that such gesture or preparation will cause any person present to apprehend that he who makes the gesture or preparation is about to use criminal force to that person is said to have committed an assault. You also will see even a gesture or any kind of preparation putting someone to the fear that a criminal force is going to be made against me, your lordship, that itself will constitute an assault, your lordship. Now, 448, your lordship will see what 448 says. 448 is the punishment for house trespass. The definition of house trespass is at 442, your lordship. If I may read, your lordship. Whoever commit criminal trespass by entering into or remaining in any building, tenant or vessel used as human dwelling, or any building used as place for worship or as a place for custody of the property is said to commit house trespass. Now, your lordship will see any government employee, if they are given a quarter, your lordship, that's their dwelling place provided by the government, your lordship, without any permission of any individual, your lordship, to come to the house and even have a closer chat, your lordship, with a different intention, your lordship, will clearly amount to trespassing, your lordship. In this case, your lordship, they have clearly trespassed. They knew that front door was closed. If they had, unlike any other friends or relatives, your lordship, coming from the back door, they knew this is an officer's house. They went there for personal work to ask for certain favoritism, your lordship. They did not come from the front house, trespass from the back compound while assaulting the entire employee, your lordship. Now, with regard to the statement, as lordship, your lordship, if I may be allowed to place the judgment that unfortunately my type got dead because of the battery situation. I'll be giving it tomorrow, your lordship. My only contention with regard to that, any witnesses of family cannot be discarded merely because that witnesses is a relative, your lordship. The family members of the victim of the court has to adopt a very careful approach in evaluating their evidences, your lordship. However, in this case, your lordship will see, even though the other witnesses were their employee, their friends, or his brother, your lordship, every one of them has stated the same fact. They have not turned down from their statement given to the police and even under their deposition, your lordship. And the circumstances, the chain of circumstances in this case has also to such an extent corroborated with each other, your lordship. And in this case, your lordship will also, if I may point out, your lordship, while discharging him of all the other offences, your lordship, at page number 114, your lordship will see
148 in paper book.
a paper book, your lordship.
One 48,
114, your lordship.
114.
Yes. Your lordship will 114, your lordship.
114, 114. 452, 442,
142,
114.
114.
Yes.
At paragraph 42, your lordship.
Paragraph 43.
42, your lordship.
42.
Yes, sir. This is the paragraph whereby taking into consideration the evidence of PW3, PW2, PW4, and PW1, he was convicted under section 354. And at page number 117, your lordship. At,
Seven,
yes, at paragraph 50 and 51, your lordship.
351.
Yes, your lordship. Your lordship will see that prior to that, since there was no charge frame under 448, your lordship, under the power provided under 222, your lordship, this section, he was convicted under this section as per these two paragraphs, your lordship, taking into consideration the evident depositions of PW1, PW2, PW3, and PW4, your lordship. In this case, your lordship, the prosecution in every best possible manner has proved the guilt of the accused under section 352 as well as 448, your lordship. Deeply obliged.
You have something to reply to what my. No, it's all right. What's it? Please. Because my lord, my learned friend.
For the informant.
Oh, yes, I am from the employer. One of my learned friend and the learned additional PP, my lord has, my lord, adequately, my lord, given the statements of the accused, the evidences of the accused before this honorable court. My lord, I will not repeat that. My lord, at the course of repetition, my lord. Subject to what my learned additional PP has cited. Now I will endorse to that.
May I please, your lordship?
Mhm.
Here, still, the prosecution case is doubtful. Why I say so? Prosecution has examined only those persons who are closely related with the informant. Then that day, there was a party going on, and the witnesses present in that party has been named. 3% has been very clearly named. Out of the 3%, there are another 4%. Total 7% was there. They were never examined. And IO has not stated any ground for not examining them. All the witnesses, my learned colleague who is going to submit one judgment tomorrow, I am very much well aware of that judgment. We have read it on several occasions. The judgment says only because a witness is closely related, the statement made by that witness cannot be discarded. Well believed. But what precluded the IO from examining those witnesses has not been cleared. That apart, lordship may kindly come to page 68 for a moment of time. Just 1 minute I will take. That is the 313 statement. I am very sorry it missed my notice. It's a common 313 statement, which is absolutely irregular as well as illegal.
Not properly recorded.
No, not only that. It's a common one. Lordship will kindly find What is your name? Question number 1. Naipi Tayu, that is appellant number 1. Now question number 7. What is your name? Rizam Melo. Absolutely irregular as well as illegal, Lordship. Page 68. This 313 cannot go.
In all the cases in that way.
Yes,
In all
how
the
it can be, Lordship?
In Arunachal,
There
in
is,
that way,
there is no,
Just a second, if I may put the scenario out of in our state, your lordship. In 313, your lordship, if there are more than one accused, your lordship, their statement under 313 is they're made to stand together, your lordship, and the same question. put up-
absolutely illegal.
Just let me, yes,
313.
Absolutely illegal.
yes, they are put up the question, your lordship, and
Absolutely against the,
Who put the signature? Who will put the signature?
Absolutely.
Who's settling?
absolutely, Lordship. Absolutely against
Your
the
Lordship will see-
notification of the Guwahati High Court rules.
if I may, if you can.
No, please.
Mayor, please, Lordship. My lord, regarding this 313.
Yes.
My lord, my lord, if you, my lord, take to this, my lord, judgment, which is under my lord challenge. my lord.
Mm.
313, my lord, there is no any whisper, my lord. And on relying on this 313 statement, the conviction has been made, my lord. My lord, why I'm submitting so, my lord? My lord, by this statement, my lord, whether, my lord, the accused has been, my lord, put to any prejudice, my lord. That is more vital. Well, nothing prejudice is caused to the accused person by this 313. Because the learned trial court never relied on this 313. This conviction was based on evidences of other witnesses, my lord, other material witnesses, which has been, my lord, put forward to this honorable court by my learned pen, as well as the, my lord, learned counsel for the appellate pen. No prejudice is caused because of this matter. 313 statement. Thanks.
Lordship, there is a judgment of our own Guwahati High Court in which I eventually happen to be a special public prosecutor. It's a case of Govind Singhal and other, if your Lordship may kindly recollect. Bhavani Singhal and Kamala Devi Singhal was acquitted because of the defect in the 313 statement. So our own Guwahati High Court, I can place the judgment if anytime required. Therefore, this is a case where 313 is absolutely defective. And otherwise also, if your Lordship looks into, if 313 to be taken, they said that we have carried the dao, but we have never used it. That is their statement, which also can be relied upon them. So therefore, here it's a custom. Customs and traditions cannot be discarded altogether. And all along, not a single person from the audit party was examined. So it cast a doubt in the prosecution case. Lordship.
Current counsel for that, none and additional. Jenny is present and Janet counsel. So for the respondent. Hearing concluded, judgment is up. This is the only judgment now.
Yes, yes, Lordship.
Okay, no problem. Tomorrow.
Tomorrow I will not be there. My colleague will be there. Biplab.
Deeply was.
Anything. Unlisted. Seriously? No. Yes, please. 20? What's the order? The same person.
My lord, it's regarding one is PS Naharlagun PS case 132 and one is Papu Hill PS case 45. So where zone arrest has been, yes, zone arrest of
Which number?
136, Naharlagan PS case 1,
132.
yes, this is 132, my lord. So
Yes, to call for the case diary. 132 CD is not available, no?
CD,
Not
but in
available.
earlier case it is available, but
It is 136.
yes.
This is one in connection with
yes,
132.
my lord, here in this instant case, zone arrest has been shown on 5th of September. 5th September. So based on that, we have to move subsequently. So in this application, bail application where means alleged accused has been linked in this case based on the 136 case.
One, whatever it
And
is.
medical report all are attached here in this instant. So my lord, may I pray that without calling CD, my lord may pass by based on the previous order that even that medical that report has been attached here in this application where it's clearly referred to TRIMS Naharlagan Hospital and this Mitpu means mental hospital for further treatment. So without calling CD, that may also pass, my lord. As my lord deemed it.
Mr. Counsel, learned counsel for the petitioner, learned additional duties, of the state. Is an application for 39 CRPC. In connection with filed by the petitioner. Filed by the petitioner, seeking bail of Ahmed. In connection with Naharlagun PS case number 132-23. Under section 380-411 by 34 IPC. For the case diary. Yes, date please. Anything else you want? That is medical report or anything? That is not required.
Here petitioner has enclosed medical report.
Yes.
I did similar in earlier we obtained from the jail authority.
So call for the case diary, yes, date please.
Uh,
Twenty-six.
yes. all right.
Granted additional PP, yesterday to produce the case diary on 26/9.
And another is case number Papu Hill PS 45 of
45.
23.
That's also on same ground, medical and humanitarian ground. And the medical report is also there. If honorable
You can call for the report of medical report of this person, no?
medical
230.
report is enclosed here in this board application.
There is a medical report.
That's an medical reports in annexer
Page number.
20, page number 25. Page number 25 till 29. As forwarded to,
They come up,
yes,
the same person.
Same.
yes.
Oh, same person in connection with another case.
Yes, here also on 11th of September, zone arrest has shown, so that's why we have to move this back.
439. Same person, re-come up, same petitioner. Just change the case number. Papu Hill Station case number. Papu Hill case, PS case number, 4523. Under section 457. 457.
457.
457 by 380.
380.
For the case diary. It's same day, 26/9.
Yes, of that.
Highly obliged, my lord.